Stand and pledge allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Isn't our secretary here?
That would be me.
Oh, that's you.
Yes.
Doing double job.
Well, yes, every day. So, Dick Boyd,
Yes.
Roberto Garza,
Here.
Skip Lake,
Here.
Carl Rubel,
Here.
Wendy Oaksma, I'm here. We're all here. Eric Gall, the alternate, told me he would come maybe later after his school open house for his child.
Right, I saw that. We need to set or adjust the agenda. Anybody? No answer? Okay. Declaration of conflict of interest? None? Public comment? Come up with to the podium, state your name.
I am Mark Mayer. I was asked to come here on behalf of Kirk and Lisa Villamont, who applied for a land use permit and was awarded that land use permit in February of 24.
You say was or wasn't?
They were, we came before the board. I was actually here at that meeting at that time. Well, unfortunately, they were not aware. It is written in the code for the board, so they should have been. They were not aware that, and I wasn't either, that expired after 1 year.
Excuse me, did you move the microphone just a little closer to that?
Yeah, sorry. They were unaware that it expired after 1 year, and they did not take advantage of that. We would like to ask for an extension on that variance that they were awarded in February of 24, which expired on February of 25. If we can get that extension, Deb said that she would award me the use permit that we're looking for now to build that garage on that property. It's case number ZBA 202305. I have a copy of pretty much everything here, but I don't know what to do from there.
Wendy? Do we
You could hear his case, yes.
tonight?
Yep.
Okay. Okay. We're open.
Okay.
Do you have enough copies for everyone?
Unfortunately, no. So this is the. Yeah.
Yes.
What she's making copies of is the original, application that, Bob Hall worked with, the Villamonts to present to you. And, they never received a letter from Bob. Bob never sent the letter out, which you'll find in record. Deb couldn't find that letter was ever sent. Again, they're not using that as a crutch. They understand that.
So that was no letter informing them that the variance was granted.
Correct. The letter was never sent by Bob. Telling them that it was granted. We were at the meeting, we were told that it was granted. But the letter never came saying that it was going to expire in 1 year. However, if you read further down in the book, it does say that it does expire. So that's not really a good excuse. And they're not trying to blame Bob for that.
They just didn't read that part.
Yeah, they discuss it and they apologize. I also have, I guess I didn't get to that one, but an agent letter that I can make copies and pass around. Sorry.
Is that microphone on?
Yeah, I'm just not leaning into it.
No, it's on.
Sorry.
I'm not sure it's on.
It's on.
Oh, yeah. Okay.
Sorry.
Is,
Basically, the variance was to ask, two things. One was they own the island on Island Lake. With that property, they also own a piece of land, a 50-foot wide piece of land on the shore. And they were asking to be able to build a garage on that piece of property. Right. That doesn't have a house.
Okay, so I think we need to keep up with public comment first, and then, come back to it.
Okay.
I believe when we discussed, we had a meeting in that last year, didn't we? That property.
Well, I remember that.
Yeah, I remember we approved it.
Good.
Yeah, it was approved. And we just let it expire, unfortunately, and we apologize for that.
So we just need to.
You sent the letter, the letter was not sent to you saying that the permit had elapsed?
Well, the actual letter from Bob saying that it got approved, never got sent.
It's not get approved.
That it did get approved.
Thank you.
You're saying, they haven't built the,
They have not, I did,
Yeah.
I did the process of I went to pull the use permit last week. And that's like, yeah, if you can pull the use permit, your variance expired,
and,
so we're ready to build now.
we're ready to build now.
Correct.
And,
So I have the use permit filled out, ready to go.
Can't do this during public comment.
No,
Maybe.
so I don't know, we like adjust the agenda and put them like at the hearing spot? No.
It's the attorney. Somebody sitting right
Yeah.
now.
Maybe you can finish his comment for whatever the board rules are, and when he's done with his comment,
Yeah,
we'll move on. And then have the rest of the public comment, and then I'm happy to address the application.
Okay, so are there any other questions for me then?
Not at this time.
Okay. So is that it then, really?
no,
Oh, so just hang out.
Fair. Thank you.
Any other comments?
Hi, my name is Michael Sherman, 8596 Church Street. I just wanted to put on the record, I couldn't make the regular planning meeting. This isn't really appropriate for ZBA meeting, but the zoning, and I thought Deb might be here. I just wanted to thank her. We're continuing to do work on Millbrook Farm, and part of that is restoring and clearing some trees and some brush, which everybody doesn't completely understand at the moment we're doing it, but Deb was very instrumental and helped me communicate with the community. And I like to be very transparent in what we're trying to do. It's a large property and a lot of people are aware of what we're trying to do out there, but we're continuing to try to restore the property. And I just wanted, the zoning administrator was very helpful. She got back right back to me because of some misunderstanding about what we were doing. And I just like to take the opportunity when we can to thank some of the administrators that normally don't get thanked. So that's all I'm doing. Thank you.
Thank you.
Heidi Valmuth, 8388 Winnie Lane, private citizen.
So,
Heidi Valmuth, 8388 Winnie Lane, private citizen. I use my outside voice. Please, I wanna see you guys take notes. Because I've sat in a lot of your meetings and I'm just cringing now. You have to understand the importance of what you're doing for the people that you represent. What you do and what decisions you make can show up in court. Please start reading your training manual because you're making some of us in the audience crazy. please pay attention. I've watched a lot of this gentleman's podcasts. They're good. And this is the training that will make you understand why we're all up here, either complaining or congratulating. Let's really dig deep and pay attention. And Carl, if you can't hear, you better tell someone. Thank you.
Question,
You're not,
It's not,
it's you, this is what I'm talking about, you don't talk to me. Okay. Sir, I was your trustee for 4 years. My personal cell phone number was on the website, and guess what? I know Sally, so if you wanna have a conversation, find me, I'm very easily. I can talk to you, it's my comments. For the love of God.
it's one way. Right now.
Mr. Attorney.
Thank you. Any other comments? Approval of meetings. January 23rd, 2025. Any remarks?
yeah, I had found. Just a small thing that I circled. Sorry about that.
The neighborhood as well.
Yep.
Guess it's such a small change, I can't find it.
More comments? Carl? No,
Good.
all right.
Any comment, you said, right? Any comment? No.
No. We have a motion to approve minutes.
I make a motion to approve the minutes from January 23rd, 2025, as they are appeared.
Second. Employee who wants to confess. The roll call,
No, I think it's the voice vote.
just the voice. Nays and gays,
Yeah.
Just, you can just say all in favor.
all in favor? Right.
Aye.
All in favor,
Any opposed?
any opposed? Motion carried.
Thank you.
We have no hearings scheduled tonight, so we'll move on to the training with Attorney Matthew. Who shall?
Thank you, Mr. Garza, and I'm here with Lindsay Kurgel. We're from Fahey Schultz Berzik Rhodes. We're the township attorneys. Our firm represents over 100, probably over 200 now townships throughout the state of Michigan. So we're really happy to be here with you, and we work with a lot of ZBAs, and whether it's helping with a specific matter or application that's before the board or doing trainings like this, it's always a pleasure to be helping local governments. Before we kind of launch in, since we have the public comment from Mr. Meyer, I think it was, regarding the variance permit that was granted last year, so I went and grabbed your zoning ordinance. Under section 20.08, the rules subsection C state that the variance granted shall become null and void unless the provisions of the variance have been utilized by the applicant within 1 year after the granting of the variance. An extension can be granted at the request of the applicant. And subsection E does say the applicant shall in writing receive the decision upon completion of the hearing. So as you kind of indicated that receipt of the decision after the hearing, which the zoning administrator was supposed to send out. Either got lost in the mail or didn't happen. So that subsection E didn't quite happen, but they were at the hearing and did have actual notice that their request was granted. The null and void language that's there in your ordinance, that's gonna have a peculiar legal meaning. Void means didn't happen or goes back to as if it never happened instead of. Like if you had a contract, oh, we have a contract and now you didn't give me my 100 apples. Now we're gonna litigate over that. It's if you void the contract, it's as if there never was a contract to begin with. So I think the proper posture for this board to consider this request would be just have them file another zoning variance application. And then you can follow the normal process and you should have all the same materials if it's the same request. And it's interesting, we have a similar type of scenario here in our training. So we can touch on it a little bit in that sense, but for all intents and purposes, I would just recommend that it be resubmitted and then this board just reconsider it just as it would if it was being submitted in the first instance without regard to the prior application. Yes, sir, Mr. Lake.
The question is of me is, does he have to pay the fee again, or is that waived?
They would have to pay the fee again, yep.
Because the administrator made the mistake?
Well, yes and no. I mean, yes, they didn't get the letter, which would have been an administrative mistake, but they were also present at the meeting, so they knew their variance was granted. It doesn't say that the variance runs from the time the letter is sent. It's really from the time the decision is made or potentially when the meeting minutes were approved. So unless that were to extend out, I mean, here we're gonna be, that was February 24 and it's August 24, so we're a year and 6 months past that. So even if it was a meeting minutes thing, I'm guessing you had a meeting within 6 months of the last one. Now, maybe not, because these are, what, you're just now approving January minutes, so there could be some facts that arise to a waiver of a fee. Or if there's a hardship provision that you have in your either the administrative rules or within the ordinance, that might be something to apply. But again, the zoning administrator can look at that, and if they'd like to request a fee waiver, they can ask the zoning administrator. And then she can kind of process that and, yep, come to a decision and figure out.
Thank you.
Where they have to go there, yep.
I have a question,
Yes.
We have a different board than we have now.
Mhm.
I don't think we had 5 members. But my problem is if our township official didn't do his or her job, sending that out, and then we went and didn't approve it this time, aren't we, isn't that taking, our official didn't do his job, which meant then that he has lost his right through an error or whatever of the township, but the other issue in that is if he did send it out, but it didn't get delivered to him. Again, it's at the post office, which is again the government. We approved it. I don't really want to go through that again. It doesn't make sense. If we can do it another way, but if that's what has to be done, but I feel if the. And I've run into this a couple times where the government caused the person to have to file an appeal. Or when we approved it, or disapproved, or in some cases you have to file an appeal. Yeah, that's my concern with it is, why should he have to go through that all over again when he didn't get the notification? And again, that was our previous administrator, and so I have a concern.
Yep,
I don't like putting people through a lot of paperwork and then having a whole different cast of people looking at it than we had then and made that decision then. Not everybody. You know what word, you know, we did give them a break.
Yeah, I understand what you're saying. Of course, we granted the variance. But there's obligations on both sides. Right, the ordinance requires they act within a year, they had actual notice, that's a big point, again, back to kind of the technicalities of the law. If they didn't know, or only their agent was here, like only the construction manager and not the applicants themselves. You know, certain things could change that fact pattern. And if the applicant has something he wants to present to the zoning administrator, whether it should come out on a consent agenda back to this board, or whether there's a different approval mechanism he thinks he can identify. That's open to them, but on the facts that we have. The variance wasn't acted on, it's now essentially not issued, so the cleanest thing to do is to resubmit it.
Sir, does that answer your question?
I think so.
Okay,
I think we're back to square one. I
Yeah.
submit, start over.
yes,
All right,
sorry.
I think that's it.
So moving to the training, so what we put together here is an overview of the zoning board of appeals, how it functions in Michigan law under the Michigan Zoning Enabling Act. And then some of the provisions of your ordinance. And then going through some other cases that have arisen to sort of highlight and be an example of how you can approach variance requests when they come, or other appeals that come to the zoning board. And then just practicing kind of deliberating on those pieces so that again, the best practices and sort of the framework of the different types of decisions this board can make. You'll get some exposure to that and some just further background and experience with it.
Request, this comes up all the time in our meetings. Could you please bring your microphone a little closer to you and talk directly into it, not like I do half the time off to the side and nobody can hear me. But I have two very expensive hearing aids that work pretty good right now, but I do need you to, maybe 6 inches closer to that microphone.
How's that?
That's fine.
Better?
No, it's not.
Sounded on, isn't
It's
it?
not. Yeah.
How's that?
Okay.
Oh, I was speaking so loudly before, it was getting picked up by somebody else.
Good job.
So we do have a disclaimer, this is still a training, we're not here to assist on a specific case. We can, as I said, provide some insight into your specific ordinance, because we are here for you, not just entirely generically. But again, we're not here to actually resolve a specific issue, so this is still more of a general presentation that's hitting on the key points without being a specific issue. So as I kind of went over at the opening slide, one of our 4 goals here, discuss the creation of the ZBA, talk about the Michigan Zoning Enabling Act. Discuss the ZBA, how it reviews the variances, it's a common request that comes to the board, very interesting, we'll see later, this board has both. Non-use and use variances, or also known as dimensional variances and use variances. You can also have appeals and other items brought to this board, so we'll touch on some of that. We'll discuss the nuts and bolts of when you have the application in front of you, how can you go through it to be clear to the public which points were persuasive on whether or not you granted something. And getting that properly reported into your minutes. Essentially creating strong decisions so that whichever way this board goes, you then have the record that clarifies and is present for the public on what happened. And then as we go through, of course, answer questions. But then you don't have to wait till the end, because as we've been doing, feel free to raise your hand or shout at me and we'll be happy to stop and address the additional questions. So just initially, you'll see a couple references to various statutes throughout the presentation. We've mentioned one of them already. That's the Michigan Zoning Enabling Act, or the MZEA, that was passed in 2006. There's also the Michigan Planning Enabling Act, the MPEA, that was passed in 2008. And both of those statutes have predecessors that existed in Michigan law. For example, there was the Township Zoning Act and the City Village Zoning Act. So it's not that zoning first started in Michigan in 2006. That's just the current, most recent statute that codifies and sets forth the specific statutory language. I'm seeing quizzical looks. Is there a question? No. And then the Open Meetings Act. So this is an open meeting, it's a public meeting, and the Open Meetings Act is the statute that lays out the requirements for public meetings.
And I'm gonna make sure, does it sound like?
Yep.
Yeah, okay.
I'm missing something.
Yeah, you're missing this one.
I'm missing it.
It's the
I
same.
have it.
It's the same, he's talking right here.
No, he thought he was missing this.
Nope, it's on here.
Right.
Number 4,
Sarah left in color. You got it in color.
Well, I'm special. I'm special. Okay,
I can't do nothing about it, it's the neighbor next door, sorry.
so I'm gonna talk really briefly about the composition of ZBAs. Obviously, you're all here, so we did something right. But the township board creates the ZBA and it can be 3 to 5 members based on population. So I believe, maybe even last time that I was in this township hall, I believe it was 3 members, and then you switched to 5. So I guess the most important thing to keep in mind about the number of members on a ZBA is what constitutes a quorum. In your case, it's 3, so just thinking about the Open Meetings Act, 3 people is a quorum. If you had a board like you used to of 3 people, that's an even scarier situation, because 2 of you talking as a quorum. But that's just something to keep in mind about the number of people on your ZBA. And then who can serve on a ZBA? Everybody above 18 and who lives in the township. So hopefully we're all clear there. And then only 1 member of the ZBA can be a member of the township board, but 1 member is required to be on the planning commission as well. The last thing is mainly that someone on the ZBA shouldn't be an employee or a contractor of the township board. That goes into a little bit of conflicts of interest. And so we're gonna have a sample ZBA here. This is a 3-member board. You have 5 now, but you know, you could add 2 trustees. So you have your planning commission member, and then you have your member of the community who's the chairperson. And then you also have your township trustee, and all of these people are 18 and live in the township. Okay, and then characteristics of a good ZBA member. You don't have to have a legal background. You don't have to have a background in municipal law, although I know a lot of you do. Here, I'll trade with
I
you.
have a question. Why don't we all have copies that we can read?
Here, I'll trade.
I don't understand that.
Because I brought copies with small print.
I made these, so you can have these, you can read those easier. Okay. Do you have? Yeah, he's good. I apologize about that. We brought the copies that. It's all right. There's spots for notes. So characteristics of a good ZBA member, mostly just passionate about the community, I think is some of the best qualities that we see in ZBA members. People who are willing to learn and willing to work with others and who are fair and impartial. And I believe many people here have also been interested in township law for a while, so. All right, and then to briefly touch on statutory duties and authority. A ZBA must hear questions about the administration of the zoning ordinance and interpret zoning maps. So if there was a question of, you know, my property is right on the border between the AG district and the industrial district, that question might come to you. And then also, they will have to hear matters referred to it by the township board. And then it's not a requirement, but we often do recommend the creation of bylaws to govern conflicts of interest and procedures as well. So while not required, definitely a good thing to keep in mind and think about. Then I'll turn it back over to Matt, who's gonna talk about the specifics of
I
your.
have a question about bylaws.
Yeah.
Do the township boards always approve the ZBA bylaws? Or
No,
can the
typically,
ZBA stand alone?
yeah, typically they're internal to the ZBA, so they'd be adopted by the ZBA.
We ran through a issue on this with the planning commission, where it is that at one time the township supervisor wanted to approve our bylaws, and it was no, they were not allowed to do that.
Right, that makes
was a
sense.
legal opinion, I believe.
That makes sense. I mean, there's other involvement for the township because the ZBA arises out of the zoning ordinance, right? So if you were an unzoned community, there wouldn't be a ZBA.
But is that the same with the CBA? Would it be the same? We do have bylaws.
So
Correct.
yes,
And,
yes,
We did approve. I don't believe we need the township board approval.
that's what I was asking and you said yes, we don't.
No, we don't.
So your ZBA is set forth in chapter 20 or article 20 of your zoning ordinance, which was very helpful, because then I clicked right to that section all the way through the rest of it, and I found your variance piece right there, and that's how I was able to come up with something helpful for our gentleman in public comment here. So a lot of that authority is there. Of course, you're gonna relate to the rest of the zoning ordinance in terms of uses, et cetera. You know, what is the setback? Will be in another section, if you were hearing variance for a setback, for example. And then Lindsay, touched on some of the powers and duties. So the reviewing, whether that's of the zoning map, or whether it's reviewing a decision of the zoning administrator that she made. Those can come before this board, and then also interpretation, so perhaps a question arises. What does agritourism mean? If we've allowed agritourism, but we haven't defined it in the zoning ordinance, what does it mean? Or another interesting thing that's coming up in Michigan is, what does residential mean, right? With short-term residences, is that a residential use? Is it a different kind of use? And if you haven't defined it in your zoning ordinance, then there might be a question about that within a specific zoning district, and someone might bring that question to this body.
Is there a means to bring that question to this body other than through a variance or?
Yeah, so they would file a zoning interpretation request with the zoning administrator. She gather the information that they're submitting, and then it would be submitted to the ZBA as an agenda item, similar to how a variance or other application would come forward. Another possibility would be if, to stick with the short-term rental example, if someone applied for a short-term rental permit or something, and the zoning administrator denied it and said, you're in a residential district, short-term rentals aren't permitted in your zoned district, they could appeal that decision, and sort of inherent in that is sort of the interpretation, so it could kind of come in that way as well. There's also different flavors of the way it can come to the board.
Okay, thank you. Would those questions come up the same as using a commercial farm building or residential?
Depends. But maybe, so. It depends for a couple different reasons. One is that often in your ag districts where you're gonna find a farm building, residential use is permitted by right. So they may not need to come to this body to convert or utilize a barn as a residential use. The other issues that might arise in that case would be how the barn was constructed, if it had sufficient egress for residential use, if the electrical was sufficient for residential use. But those would be building electrical code issues that would not come to this body. So for example, if I have a barn on a 10-acre parcel and I want to refurbish it to be a single family residence, and single family residence is permitted by right in that zoning district. I could convert it to a single family residence without coming to this body. I would just need to get the applicable building permits and if I'm really on my game, I get a zoning compliance permit from the zoning administrator who says, yes, single family is permitted in that district, and I recognize now that this is a single family residence.
And those people would have, that structure would have to undergo the inspections of the electrical and sewer and all that kind of stuff like a home, right?
Correct, it'd have to be inspected from a construction standpoint as a residence.
Thank you, sir.
So we touched a little bit, I mentioned the appeals, and there's authority on both sides. The state law, the MZEA, provides that zoning boards may and even shall hear appeals. Again, as a decision of the zoning administrator or other requirements or orders that were made under the zoning ordinance by an official charged with its action. And then that's implemented in your zoning ordinance there, again in that Article 20 and then in subsection 6. And then it's also stating that the ZBA has the powers that the state law gives it. So everything in the MZEA is also going to be something that this body can hear. So then moving into variances a bit more specifically. A variance is different from an appeal, so you could have, let's consider a setback for, let's think about our barn again that we're converting to a residential use. So it's there on the property, but let's say it's 30 feet from the property line. But now the setback is 50 feet. And the zoning administrator says, no, I can't give you the compliance permit for that single family residence because it's not compliant with the setback requirement. They might appeal that decision to this board and say, hey, we think she got it wrong because, you know, the building was there before and it's really a rehabilitation, not a new build, and whatever the other reasons are. And then this body would hear that, deliberate it, hear both sides of the argument, consider the language in your ordinance and arrive at a decision. Now, let's assume that you deny it. You say, no, that was built as an ag building, when a time and setbacks were different. The setback is now 50 feet, and if you're gonna modify it to a new use, you're gonna have to comply with the new setback, so appeal denied. We agree that the zoning administrator made the right decision. They get that answer, they're kind of bummed out, but then they apply for a variance. So a different thing. Now they come in and say, hey, we want to be able to refurbish this building and put it to a new use, but we can't do that because it's 30 feet from the property line and we're required to be 50, so we want a 20-foot variance to be only 30 feet from the property line. Now you'd be considering not an appeal of the administrator's decision, you've already resolved that. Now you'd be considering whether or not a variance of that setback dimension would be appropriate in that hypothetical case.
With this board.
Correct, at this board, yeah.
We had. Conditioner, my green dot, there was a, when it comes to if you're rehabbing a building. Fire damage. Wind, updating it. As long as you're not increasing the amount of that it's violating, you're fine. Now you have a complete teardown. As this building is no longer serviceable, we have to build a new one. When we did that in 1999. We were told, no, you have, can't, I was gonna build one like my other house, which was 10 foot. It was 90 feet or 70 feet wide and we're around 60. They said, no, you can't do that. You build all the building, you have room in here to build a nice house. It doesn't have to be 70 feet wide. So we said, okay, fine, so we redesigned it a little bit. Some people still try to say, well, that's included under the what's called the what do you call
Grandfather.
grandfather clause, and say, well, there isn't. If that's a complete tear down, to me, what I've been told, you have to obey the ordinance, if you can.
Correct. Yeah, so that's touching on another aspect, which is the grandfathering or the prior legal non-conforming use. Which is really, it's a distinct zoning issue than a variance issue. But to the point, and as you make it. If there is a non-conforming use. Then it can be continued and even maintained and some repairs made if there is some damage, as long as it doesn't expand the impact of that non-conformity. There's other restrictions under Michigan law.
We're told in the book. Eventually, the goal is to get rid of all non-conforming properties.
Correct, yep, that is,
And in some cases, you can't do that. You know, you got a 50-foot lot. Well, you know, you're gonna have to allow them if they can build a smaller house, maybe, you know, it's just not always possible. And that's why you go to the ZBA.
right, so, and each specific case is gonna be different about whether we're talking about continuing a non-conforming use, and that's the issue, and it's an interpretation question, or whether they had something and they're on a 50-foot lot, and now it's a variance question of, can we continue to do something, but to do that, we would need a variance, and we would go through the criteria on each specific case. And you're correct, it is also in statute that the public policy of Michigan and the goal of zoning is to eliminate non-conforming uses over time. So again, that drives a lot of the other than particulars when you deal with a non-conforming use. But coming back to variances, they have two key components. One is that there's some sort of practical difficulty at play, and we'll get into some of what that means. It's a term of art in law, so it's different than just looking up practical and looking up difficulty in the dictionary. And then also resulting from the physical characteristics of the land. That's where the variance really comes into play, because there's something about the property itself that is creating this practical difficulty. Without getting too far into it, with this barn example that we sort of brought up, it's an interesting question. Well, that barn has been there for 30 years, so is that considered a physical characteristic of the land because it's a fixture? Gives you a hint of how interesting zoning and variance cases can become. Mentioned at the beginning that this board can grant both use and non-use variances. That's especially for townships, something that's more unique given the way the MZEA is structured and the changes they made in 2006. So we'll touch on your use variance provisions as well as your non-use variance provisions. And there's different standards, as you'll see, for both kinds of variances. So your typical process is the applicant, knows their property, knows what their intents are for it, so they see the need for that variance. So they're the one that comes, they apply to the zoning administrator, it comes to the ZBA. The ZBA will hold a public hearing, so you'll open your meeting, you'll be in a public meeting, and then one of your agenda items under hearings, you'll have that public hearing. And that's another opportunity for the public to speak specifically on that agenda item, whether they're in favor, whether they're opposed, whether they have a concern about a particular characteristic that might need to be protected and a condition that might they think is appropriate. And then the public hearing closes, this body deliberates. Here we just have kind of the one prong, is typically it's possible to resolve in one meeting. You get the facts, you've had the packet, you're able to come to a decision. But if you need more time, there is the ability to have an additional meeting after that public hearing as well. You may also, well, there's lots of other exceptions. You could have a special meeting and then resolve it at a regular meeting to help, to accommodate some schedule. But that's the essential piece of it, right? It comes to this body makes a
And we
decision.
can hire experts to help us if we need to.
Yes, absolutely.
We have the ability to spend someone and say, look, we don't wanna do this. We can hire, an engineer or whatever. So it there doesn't need to be rushed to conclusion if we're not the experts.
Correct, whether that's a variance or other matter that comes before the ZBA.
This brings up the same question this gentleman here has. Let's come back to the board to get his okay renewed or extended,
Correct,
which you just said.
correct.
Reading this and listening brings a question to my mind. Doesn't the board have a right of suggesting to the zoning administrator just to go ahead and give it to him because it's been past months?
No,
Okay, that's what. That's where my question came in when you were talking about it.
mhm. And then after the variance has come before the board and you make a decision, whichever way it is. There's an aggrieved party, there's an appeal right to circuit court, and then even to the courts beyond that. So and that's gonna be true of any decision along the governmental spectrum. There's going to be an appeal right somewhere, whether that's to another board, as an individual appealing a determination of the zoning administrator, right? The first appeal is here, and then they can appeal further. Same with anything else. So getting your meetings set up and the requirements for that are a little more than just the Open Meetings Act requirements of having a public meeting. The public hearing is another level of notice to the public that's set forth again in the Zoning Enabling Act.
To back up a second, when we talk about variance requests, there's two conditions, dimensional variances and use. Now, I read somewhere that there are some cases, I don't know if it's whether it's a township or where you cannot have use variances. And others where you can. And I recall going through that Michigan State courts that that gets a little tricky. Use variance, and isn't there some conditions where you cannot issue use variance?
Yes, we'll get into that in a little bit.
Okay.
So going back to the public hearings, when you have an application for the first time coming and you schedule your public hearing. There's publication in the newspaper that goes out, and it has to be published in the newspaper at least 15 days before the hearing. Which typically means the clerk or the zoning administrator needs to get it to the newspaper 21 days before the public hearing. Just to get it in there in time, and it describes the request and where the property is, and then tells you when the meeting is, so that folks can show up or send comments. The notice is also mailed to individuals around the property, so within 300 feet of the area where the variance is being considered, or the property that had the application denied that they're appealing. Gonna get notice to those surrounding neighbors because they're the ones most likely to be impacted. Since they're right next door, literally, and so the Zoning Enabling Act has not only public notice via the newspaper, but then also specific notice to the neighboring property.
I have a question. What other notices have to be mailed out or publicized? Other than the item that you just talked about? I mean, things that go on in the township. What needs to be publicized besides that public hearing?
Yeah,
What would be required under the Open Meetings Act? So I believe that your board has special meetings. And then, does it have one yearly meeting besides the special meetings? The special meetings are required to be published 18 hours in advance of the meeting, posted in a prominent and conspicuous place on the township hall, and then on the website, if that's the type of thing that you normally post on the website, then is there?
So, and then any other public hearings that get scheduled are typically gonna have this same requirement of mailing and 15 days notice in the newspaper, especially in the zoning context. Special use permits are probably the next most often noticed item. Because a special use permit typically is gonna have a public hearing. And then, so since there's a public hearing, it's gonna require publication in the newspaper and the mailing to surrounding property owners. Then there's other statutory mechanisms that have public hearings, like special assessment districts. They have their own notice requirements that are consistent with and actually even more stringent than these public hearing notices. Does that answer your question?
Yeah, I was just wondering about maybe, for example, the category change in property, you know, from agricultural to residential. Those don't have to be published.
They do, that's a great point. So that's gonna be a zoning ordinance amendment. And so whether you're amending the zoning ordinance to, let's say, add short-term rentals as a use within a certain district type. That's gonna be a zoning ordinance amendment. Which can require public hearings. Now, mailing notice there wouldn't be required in that example because there's no neighboring properties, right? If you're saying we're gonna add short-term rentals to the R2 residential district. Well, there's 37 R2 parcels. We don't have to mail within 300 feet of all of them. There's actually a provision in the zoning, the enabling act that specifies that. If, however, you were changing in your example from one ag parcel to industrial or commercial, as you suggested. Then you would have a public hearing on that change, which is as a map amendment or rezoning is also a ordinance amendment. And you would have a 300-foot mailing obligation because we're talking about one specific parcel that we can identify and easily figure out where those 300 feet are. So essentially, if you were talking about 10 or fewer parcels, then there's going to be a mailing requirement as well as notice in a newspaper. If it's more broad such that it's impacting the entire community, like a global zoning ordinance amendment, then it's typically just your notice in the newspaper, and then, as Lindsay mentioned, posting at the township hall and on the website, that sort of thing.
Is the newspaper, we ran into this recently. That it has to be published in the township newspaper of record. In other words, in the township somewhere that there is a specific newspaper that has been designated that we have to put the notices in, and it could be put in other ones. But we ran into a situation where we didn't know that, put it in Traverse City paper, and somebody came to the meeting and said you were supposed to put it in the Elk Rapids paper. That's the township newspaper of record, which we knew nothing about. Is that really true or not?
So it has to be put into a newspaper that circulates within Whitewater Township. So we see sometimes bigger newspapers being used as long as they circulate within the township. It doesn't have to be Whitewater Township newspaper, but if it's the Traverse City paper and that gets here.
But do we have to specify somewhere in our township records the one that we must use?
No.
I think it's in our policy book that we would use, yeah, the Traverse City Record Eagle, but we've been using both.
Okay, so we could change that.
It's a board policy.
Yeah, fine, okay.
That brings me back to ag or commercial property being used as residential structures. That would have to be known, let the people know that this is happening, or does it have to come to this board?
Probably not.
Probably not.
Thank you.
Article 4 of the special of the use regulations.
So it's not gonna come to this body, because it wouldn't be an appeal or a variance. It might go to the planning commission if there's a special use. Desired. So if we go to, Article 4, very helpful. Is, has your residential district, or I'm sorry, your district uses, and if we look at the commercial. 407, uses permitted by right, all uses permitted in the R1 or R2 residential districts. So in the commercial district, you can do your residential uses, which is going to include residences, so that would not need to come to this body or even the planning commission. Absent some additional, language.
Yeah, there it is.
We talked about that, okay, so our non-use. Variances, actually, I'm gonna go to use variances first and then go back. Very dangerous to skip ahead and tell you I'm gonna go back. But I don't wanna forget your question, Carl. So you're correct and you're remembering correctly from the MSU extension of the class you took. In the MZEA, there's a specific provision that if a township has granted use variances in the past before the MZEA came into effect in 2006, like I said. So if it was in the zoning ordinance and you were granting them under the Township Zoning Act, then that authority continues, which you have here. So you had that in your prior zoning ordinances and you continue to have it in your zoning ordinance. So that's why this township can grant use variances. Most of the townships that I've represented, they don't have use variances. Either they never had it to begin with, or sometime in the last 20 odd years, they decided they weren't using it, and so they pulled it out of their zoning ordinance. So it's a different type of variance, because it's talking about the actual category of land use, which we've touched on here with the, say, residential and commercial. If we didn't have this language in your zoning ordinance, and residential uses were not permitted in the commercial district. If someone wanted to do that, then they could appeal here and apply for a use variance to say, I think I should be able to use this property for residential, and here's all the reasons. I have residential on the other side, I'm buffered from the commercial, they're making more noise and smells and things than I'm going to, and I'm fine with that, so. They'd make their case, and they'd have to address then the 4 requirements of your zoning ordinance for granting those use variances. So the first one is that the property cannot be reasonably used for any purpose permitted in the zoning district without the variance. So again, everything's going to be very specific because you're gonna be talking about the particular district it's in and the composition of that parcel. But let's say it was a small parcel for some reason, maybe they would argue that, okay, it's too small for any kind of commercial uses, but you could fit a decent house on it, right, for whatever reason. The need for the variance is due to the unique circumstances particular to the property and not generally applicable to the area or other properties in the same zoning district. So again, going back to that practical difficulty idea of it's the property, right? There's something physically about that location that's important. Comes up again here. Again, if you've got a small parcel, that could be a reason, and most of your commercial parcels don't have that issue. They're large enough for the uses, they're being used for it, not a problem. And or in again, the hypothetical, if there's a lot of residential around it, maybe that's a difference that applies to this parcel and makes it unique versus other commercial properties.
Another piece of property that you're saying that the other commercial uses in that zone won't work on this piece of property.
Correct.
It's kind of hard to believe, but could be, but there, we come up with something that it could be unique to this property that had say it had a flowing well on it. Mineral water or something that you could then be tested and bottled and served, and if that was not permitted. But here, it wouldn't apply anywhere else. And this piece of property's got this water flowing on it, and well, what are we gonna, they can make a case saying, hey. We can do this and we think we can make a living doing this. So that would be a good case.
Right, yeah, that's an excellent hypothetical. If you have this mineral well. That presents a commercial opportunity or perhaps an industrial opportunity, but it's not jiving with the district they're in. But otherwise, they're able to use it. And another good point that this brings up is. We try and think of a lot of different land uses when we put a zoning ordinance together, and when you do your master plan, you're doing your visioning, your planning commission is getting all the insight from the community. So when the planning commission and the township board are doing that zoning work, they're trying to come up with the best uses and what's the future of the community gonna look like. But you don't get them all, right? Especially something very unique. As mineral water or maybe some other natural resource on a parcel, that then you have a unique type of use, and that might prompt a use variance or even a special use type request. Then the third criteria would be that the problem and resulting need for the variance has not been self-created by the applicant or predecessors in title. We'll touch on that a bunch more in our other slides. But again, in this hypothetical, again, it's the spring that's the issue, or the smallness of the lot that predates. The need here would be what you'd be looking at. And then fourth, whether the variance will alter the essential character of the area. And then you get a little help. It says in determining whether the effect of the variance will have on the character of the area, the established type and pattern of land uses, the natural characteristic of the site, and the surrounding area. Right, so I already even cheated ahead a little bit. If your parcel was surrounded by residential, then that makes it more likely that a use variance for residential would be permissible. Or if it's a commercial parcel that's close to the industrial district, maybe you can allow a use variance for something more industrial and beyond even the scope of commercial. So they're interesting cases when they come up, but it's a helpful tool because again, as much planning and good thinking that goes into zoning, there's unique circumstances that can arise. So then I did back up and went back to our non-use variance criteria. This is the lawyerly way to say it because you're either a use or you're not a use, and so non-use covers everything that's everything else that could be out there. The typical way is to say a dimensional variance, and most of those variances are going to be setbacks or maybe a parking. How much parking do they need? Do they need more or less parking? You can have other interesting types of non-use or dimensional variances. For example, you could have some density calculations or landscaping criteria that come up. And okay, that's a numerical thing, or it's not about are you an industrial factory or are you a retailer? Those would be uses. This is about some other aspect of zoning compliance that would be non-use. Again, there's a practical difficulty requirement to be shown, and this is both a legal term of art and then the zoning ordinance gives you the 7 criteria to consider when the variances are requested. So if they satisfy the criteria, then they've essentially established a practical difficulty. So your first criteria is granting the variance will not be contrary to the public interest and will not be contrary to the spirit and intent of the ordinance. So for example, if you had an agricultural parcel, that's going to be a use variance. Let's say you had again, an agricultural parcel and they wanted to do something that was permissible. Let's say build a barn. But the barn is gonna cover 80% of that parcel for whatever reason, the way it's organized. Well, one of the intents of the agricultural district is to preserve open space. So having a parcel that's 80% occupied by a structure or other impervious surface, that might raise questions as to, that's really contrary to what the zoning ordinance is in place to protect and preserve. And is it proper, or is it going to impact the public interest in some way as set forth in that district? Question? Not yet, okay. Your second criteria is granting the variance shall not permit the establishment within the zoning district of any use which is not permitted by right within the district. That's essentially a way of saying your dimensional variances aren't use variances. Granting the variance will not cause any significant adverse effect to the property in the vicinity or in the zoning district within the township. So interesting wrinkle there. One, you're looking at the neighbors, which isn't entirely surprising, right? That significant adverse effect to property in the vicinity. And here you might be looking at, depending on the variance type, if it was a parking variance, could it potentially overflow parking onto, off street? Is that gonna affect, if you're in a neighborhood, let's say you're in a neighborhood and someone wants to put a church there, right? Great, we'd love to have a church in the subdivision, but there's really not a lot of space to put a big parking lot there. And so they can't get enough parking spaces that they'd be required to have under the zoning ordinance. Maybe they could apply for a variance and say, hey, we, 10 fewer parking spaces, we need 50 under your zoning ordinance, let us build this with 40. Okay, that's the ask. Well, is that gonna cause the parking to flow out on the street, right? And so it'd be a conversation of what's the calculations of your parking and what do they expect? If they're a small congregation, then maybe that's not an issue. If they're a big congregation and they want to have school and all this other stuff, well, then we think you're really going to need a lot of parking. We're concerned about the impact to the property in the vicinity. Again,
I'm having a little trouble understanding that non-use, if we have a use variance where we want a dimensional shift, but what do we, I'm just having a little trouble understanding the condition that would apply to, I mean, when you say there's not the parking lot's not big enough, you're saying you're letting them have a smaller parking lot,
correct.
but what is the non-use portion of that?
The number of parking spaces. So if we replace non-use with dimensional, it's a dimensional or numeric component. And the numeric issue here is the number of parking spaces in that hypothetical. Well, so just like in a setback, we're saying, okay, normally it's 50, we want to build 40 feet. Okay, it's a 10-foot variance. In a parking example, we're supposed to have 50 parking spaces, but we only want 40, or we can only have 40. So we want a 10 parking space variance instead of a 10-foot variance.
You're saying, let's see if I can put this another way then. You're required to have 50. Yes. So wait a minute, it's not big enough, so we want this 40, but this will be a variance saying that. How do I put that, will not, would be less. Yeah, here. Where's the non-use?
You've got it. You've got it. You just, it's hard to put it into words. The benefit for you here, they're gonna come to you with that. They're gonna have the application, they're going to be able to explain and tell you precisely what they're asking for.
We're not able to use this property as the 50-foot, but we could use it for 40 feet.
Correct.
That's kind of what you're saying.
Exactly.
Something like that. Okay, so we we just can't quite meet the requirement with this piece of property, but look, we could do this thing pretty reasonably on this in spite of that.
Correct.
You know, maybe wouldn't anticipate ever really needing the 50 parking. Is that example? See, you know, we're not gonna have that many people, this thing isn't big enough to accommodate, but it would accommodate this smaller. Something like, something in that, yeah, okay.
Correct, yep.
Almost, made a mistake there, but.
Yeah, I knew you were gonna.
Full hall right now.
You know, swing your.
So then continuing on through your non-use or your dimensional variance criteria. If there are practical difficulties on the site that unreasonably prevent the owner from using the property for a permitted purpose. Without presenting an excessive burden and the practical difficulty not resulting from the act of the applicant, which we saw on the use side, the same piece, that it's not the fault of the property owner that causes the need for the variance, it's the property itself or the practical difficulty. The variance will do substantial justice to the applicant, but the decision will not bestow the property special development rights not enjoyed by other properties in the same district, or which might result in substantial adverse impacts on properties in the vicinity which may endanger the public health, safety, or welfare. So we've already thought of some adverse impacts in one of the previous criteria. But here we're building it together in sort of a two-pronged piece. One is there's some fairness for the applicant or the property owner to do substantial justice, right? They have this property, whether it's bottling natural spring water, or whether it's getting a church built, and they want to do something productive with it. How can we promote that? Or allow them to utilize the property rights that they have in the property they own, while at the same time not being so different that this is really a unique development right that now they're gonna have that nobody else has. All the other natural spring water plants had to comply with their setback requirements, or they were all required to have X number of parking spaces, you know, but now they're gonna have this new special development, right? So variances aren't that, they're not a special privilege, they're a recognition of a unique circumstance. Number 6, the requested variance is the minimum necessary to permit reasonable use of the land. So again, if they could, let's say if they're asking for a 20-foot variance. Well, do you really need to be that close? What if it's only a 10-foot variance? What's on the other side of the lot, so to speak? You know, if you move that building 10 feet over, or the fence or the parking lot or whatever, what have you. Are they really asking for the smallest? And minimum necessary, again, is something that you're gonna look at in the specific context of the application that's presented to you. On one hand, we don't wanna be so precise and lawyer-like. Really is it the absolute minimum? I can think of one situation where you could use one less foot. No, we don't need to be that precise about it, but at the same time, it's ensuring that it's a reasonable request that isn't over asking. So it's not absolute minimum, but and it's also going to depend on the variance that's being asked and the use even that it's in connection with. And of course, always, we're going back to the property itself. What are the circumstances that brought the variance here? What's the practical difficulty of the property? You might, in one meeting, approve a 20-foot variance for a setback and deny another 20-foot variance for a setback because the properties are different. And then again, the practical difficulty is not self-created.
I can think of that applying to drive-in restaurants. Because you could have one where it'd be perfectly fine with the drive-throughs. But instead of, you have to have 40 parking spots, say, look, we don't have room. but 30 would work, and we don't even anticipate having even more than 20, because we're. You know, emphasizing the drive-through, so I would think that would be a case where you want to think about it.
Right.
But it would also depend on, you know, the surrounding roads and community, and, you know, you wouldn't do it all the time, you. Like you say, it's a special property, special location. These things need to really be considered.
And the other benefit, that you have as the board, and you have a hard enough job, right? It's, someone's asking for something outside the ordinary, whether they're appealing a decision or asking for a variance. And that's a hard request to consider. But one benefit you have is they bring that request, they have the burden of showing that they've satisfied these standards. So they should have that information in place that allows you to come to a decision one way or another. And if it's really lacking, then, well, again, specific situations, but that's where, again, potentially there's a second meeting, maybe there's more information that needs to be gathered, or maybe something isn't clear to this board based on everything was in black and white. And, you know, if we had this in color, it would be a lot easier for me to see where the wetlands are. So why don't you print this in color and bring it back, you know, at our next meeting. And so something like that might happen, right, where you just need that additional information before you can really judge a criteria. But generally speaking, you have the benefit that they're gonna bring that request to you. And again, you know, we were going over the parking thing, they have the obligation to make it clear what they're asking for. We did the use variances, so getting into some of those specific words and phrases, like I said, the hilarious special legal meaning, so practical difficulty. Not defined in the zoning enabling act, which is a lot of fun because that's another thing that you sometimes have to deal with, are zoning ordinance terms, which are not defined. And then the state legislature goes ahead and gives you a term and doesn't define it either. Well, what does that mean? There's a lot of case law interpreting and applying practical difficulty. And then we do have our own standards, of course, in the ordinance as well, but we can pull out some themes, not self-created, right? And we've touched that in the criteria itself. It's the unique circumstances of the property. So it's not something that's shared by the other properties in the district, right? This is something unique to this commercial property, not something that all commercial zoned properties face. The particular request or a lesser relaxation of the ordinance standard would give that substantial justice to the landowner or the neighbor. There's a good reason, right? We can see why they have these property rights, and it does allow that piece that they have a right to do, as any other landowner would, to continue with. So that substantial justice piece, and then the strict compliance would unreasonably prevent the landowner from using the property for an otherwise permitted use, or would render the conformity unnecessarily burdensome. So that's again where, what is the minimum variance necessary, right? Maybe it's possible to squeeze 50 parking spaces on, or build with special materials like steel instead of wood framing or something, and then we can build in a manner that we could have the 50-foot setback. But is there a point where that becomes overly burdensome for the use that's issued, that's being asked? And again, everything's going to be case specific, but it allows you to bring in really a reasonableness standard. It would unreasonably prevent the landowner from using the property in a way that's otherwise permitted. It's a commercial district, we can have commercial activity. That's what we're trying to do with our spring water. And it's these other outside factors that are making that unreasonable.
So in other words, you're measuring the burden versus the benefit, you know, how much burden is put on the community versus the benefit that the community will enjoy.
No, I wouldn't put it quite that way. The burden piece, for sure, what's the burden on the property owner if the variance isn't granted? Is it impossible to have their single family home or their mineral water commercial establishment?
Or the church one.
Right, or the church one? Or is it simply an annoyance? Is it just gonna cost them more because they will have to use a slightly, maybe they'll have to get an architect that they didn't otherwise have to have, or maybe it'll be some slightly more expensive. And the impact, it's not a weighing of, well, it's gonna benefit them a lot and only annoy the neighbors a little bit. It's not that, it's is it going to create problems for the neighbors in that substantial adverse impacts, right? Is it substantially gonna hit? Again, with the parking, let's go to the church example again. If one or two cars park on a Sunday morning, that's not a substantial impact, even though that's a little bit of off-street parking or on-street parking rather. But that's not that substantial and it's only Sunday mornings. But if it's another 30 cars and it's Sundays and Wednesdays, and they've already told you they want to have events on Friday nights for the youth league sports or something, it's like, well, now we're talking about a lot of parking on the street. That's a substantial impact that's really going to be felt by the neighbors. So the self-created standard, we've seen that word several times throughout, and it is a bit of a tricky one. We have a couple examples here from, again, case law, so situations where the issues have come up in the community and then have gone as far as the Court of Appeals or even higher to say, hey, was this something self-created or was it something that was independent of the applicants and related to the property? So one example of a self-created problem, here we had a landowner that partitioned or subdivided or otherwise altered the property after enactment of a zoning ordinance. So you had the zoning ordinance go in, is applying to the property, and then the property owner changes the property themselves, rendering it unfit for the uses in which it was zoned. So now I can't build a single family home because I made it, altered the elevation and it's too steep or something. Well, there the landowner brought that dirt in and changed it or whatever the facts were, but the physically altering the land, that was self-created, right? They did that. And you can see that case came out of Detroit in 2018. An example of not creating the problem, so simply purchasing property and having that interest with knowledge that it's subject to certain zoning ordinance requirements. Hey, this is a residential parcel, or this is a commercial, not an industrial parcel. I'm still gonna buy it anyway. That is not itself a self-created harm, even though the person did it, right? I myself went out and bought this property hoping to use it for an industrial purpose, even though it's commercial. Not a self-created hardship. I still have the ability to ask for that setback variance or that use variance that pushes it a little more towards industrial. And we use the other criteria to evaluate that. And again, that's also that same city of Detroit case, so where they're balancing, they're discussing the different factors. If it is self-created, or another example would be where the applicant receives the variance but fails to act on it, and then it expires. So it is similar to what we had come before, which is, again, like I said, pretty interesting that we see it later. When we dive into the facts of that case, there was also a zoning ordinance change that occurred. So it is, again, at least on the facts that we have and what was presented tonight on the variance question, that's going to distinguish, that's a difference between the two. And again, they were, well, I think we have some more facts on it. So we'll get into that later, but the more principal piece is if the property owner had the ability to do what they are now coming to ask for previously, then it may be a self-created hardship if they simply didn't seize that opportunity. But as we'll also see, the facts, of course, are going to matter. Not a self-created hardship, increasing the taxable value of the property and the comparatively low rental income derived from the property, making it no longer economically practicable to operate the land use, is not a self-created burden. And we'll see, we have another good example of this. So how economics and how the market impacts something, that is itself not going to be self-created hardship, right? You can see it was a market factor that created X. So that in and of itself may not be enough to say, oh, that you created a substantial, or I'm sorry, oh, you self-created this problem you're now trying to solve. Look at the tension between these two bullet points on the bottom. One is saying you have a variance, but you failed to act, that is self-created harm. The other is saying, well, maybe some of these economic factors, your tax burden, plus the income from low rental housing, you know, that's the market, that's external factors influencing. Well, what if the property owner could have built those earlier? What if the market changed in the last 6 months? You know, is there an expectation for them to act, you know, strike when the iron is hot? So you can see how the complex and different pieces of information are going to make a difference. And importantly, this is something I tell all my boards, you can disagree, right? One board member might think, you know, the market is totally irrational. It's not a living thing, the market, it's not out there climbing a mountain somewhere, huffing for breath. I don't see that as a problem for the applicant. Another board member might think, no, you can predict these things. They've been talking about interest rates forever. Everyone knew that was going to happen. You had the ability to do what you wanted, and now you're asking us for a variance because you didn't act fast enough. I think that is self-created. Weighing the same information and coming to different conclusions. Continue to drill down into our self-created standard. Consider whether the applicant took some affirmative action that is now creating the need for the variance. Was there an unusual land division, right, that they did? And oh, now my parcel's too small. Well, it wasn't too small before you did that parcel division, so it's kind of your own fault. Building a house that consumes lot coverage maximums. Oh, I built this, you know, wonderful, beautiful house. Now I want to add a garage, but I need an extra 10 feet. Well, the parcel was vacant before, and then you made the decision to build where you built and cover the parcel the way you did. That was your choice and your action. Is, oh, well, there's a pond here, you know, natural feature that's a physical structure or physical feature of the property. Well, you dug that pond and in fact had to get a permit from the county 3 years ago. So now we're not talking about natural wetlands. It's different ways that something can be self-created.
So with the garage example, if the previous owner had used up all the space, then it's not self-created, right?
It is self-created because it's a predecessor in title. So someone is.
Buyer beware.
Exactly, yeah, buyer beware. So it's someone else took the affirmative action, an individual who owned it took that affirmative action.
And yet, and then the previous, now the current owner knows the way it is now,
Correct.
and it had, whether it can change or not, so he's got it now.
Right, so yeah, he buys it with the knowledge of the zoning and how it's impacting it. Again, it just gets super interesting, which is why it's so much fun to do this stuff, because you see interesting things and interesting questions. Consider a deck that a previous owner built. And now it needs to be repaired or replaced, or there's a need to modify it in some way. And it's encroaching on the setback. Well, self-created hardship, prior owner, built it into that setback where it was, just barely valid when it was built. But then you have this new owner and what they're asking to do is maintain it, right? Or change out from wood to composite, and it's gonna require them to do X, Y, Z. There, you can see the substantial justice there of, it's not enhancing or making more of a variance than needed, it's the minimum variance necessary. We're only replacing the deck where it was, and the deck already existed, and we're upgrading it, making it better for the neighborhood, not worse for the neighborhood. Maybe that is a situation where what the actual problem is the fact that the deck deteriorated, not the fact that the prior owner built a deck. Right, so how that action, because ultimately, a person did something at some time. And so self-created by somebody doing something. You could but for cause that back to, the butterfly's wings in China changes the traffic in LA, but we stop at some point, right?
Question. A piece of property builds a building on it with a permit of being a commercial structure. But the size of the structure also could be used as a dwelling. Oh, someone else buys that piece of property and they want to put a house up in front of this structure that was permitted as a business. That's two dwellings on one piece of property. And it's not permitted.
Okay.
Whose fault is that? The person that bought the property because he didn't go to the township and check it out to see if he could do that?
Maybe. A lot of different ways to skin this cat. If I heard you correctly, you said they want to now build in front of that other structure.
Yes.
That's self-created. It's their desire to have a second structure that's causing the need for the variance.
Then they gotta go before the township for the board to get squared away.
It would weigh heavily against granting that type of variance for it. On the other hand, are there two residences there? And could that other commercial building, even if it, let's say, has had some restroom facilities and maybe a staff kitchen, let's say, so it could be a dwelling unit because you've got a bathroom, you've got a kitchen. If it's clear that it won't be used as a dwelling and they're going to use it as a pole barn for storage, and that's clear on the permits and that's the permitted use, then now it becomes an accessory structure to the new house they want to build in front of. So there might be a way for them to, this hypothetical property owner, to achieve the goals they're looking for, but they're gonna have to work within the confines of the property that they've purchased.
Thank you.
So yeah, then here we have that note where self-created does include the current property owner as well as previous property owners. And there's some case law there. We're citing this case from the Michigan Supreme Court where there was a predecessor in title of a prior family member, family owned the property. They made changes to the property, then it got passed down to another family member. Well, that other family member was bound by the decisions made previously in the self-created context. So we're looking for those affirmative actions that alter the property. So getting into another specific or real example, and Lindsay, feel free to add on to this because we only fit so much onto the slides. I don't even know how many times I've said specific to the property, if this was a drinking game, we'd be in trouble. So in this case, which is from 1998, or I'm sorry, 1988. The city enacted the zoning ordinance and residential buildings had to be on parcels that had at least 3 or 30 feet of frontage on the street. So 5 years later, then a landowner purchases a property. And it's adjacent to another lot in the city, the property itself, so we have one property or parcel and then we have a lot. The property only had 15 feet abutting the street. The landowner used that property as a side yard to the lot, so the same person owns both pieces of real estate. 7 years even. Then the landowner wants to sell the lot, but they want to keep the property. And now they have a street frontage problem, so they're requesting a variance. The court affirmed the ZBA's finding here, so the ZBA found that the difficulty was self-created and the court affirmed. The court found that the practical difficulty wasn't caused by the zoning ordinance, the issue wasn't the amount of frontage you needed. The issue was the decision to separate the parcel from the lot and sell off that second piece of property, whereas before the landowner used it in conjunction as if it was one zoning parcel, let's say, and used it for the side yard. To now the decision of, oh, I want to be able to transfer this separately because actually I have a different deed and it'd be great if I could get some money out of that. Well, you've already used it, property owner, for 7 years in this context as if it was one whole unified piece of real property. We're not going to allow you to make you yourself make a change that's going to require that variance of frontage. And I love that Lindsay is nodding her head, because we actually talked about this slide coming up and she's like, oh, it's so complicated.
It's reading that case for a while.
It makes me wonder how it got to that place and, how did it get to that point? Like, how did they buy a 15-foot lot?
I was confused by that too.
Yeah.
They had actually 2 lots, but one wasn't at issue and one was platted and one was unplatted. But the point was that they used it all as I'm gonna have one big property with a bunch of side yards. And then just 7 years later saying, maybe I can sell this side yard and build a residential property on it, but they made that choice to then stop using those as side yards. They bought it when the zoning ordinance was in place, they knew about it. So they did that was self-created. I think that's an interesting case.
Yeah, stuck with it.
Well, that's right here in Williamsburg. There used to be 2 streets in this Williamsburg that are no more. And they've been used for years and years and years as yards. That setback could result of that structure.
Those are vacated alleys.
Right, so yeah, that, when you're talking about vacated streets or streets that weren't platted but never built on, those raise very interesting zoning questions. And whether they were properly and formally vacated or just never used and people, have been storing their stuff on them or using them as side yards for barbecues. And then how does that impact your setback determination? Yeah, super interesting. With different wrinkles all along the way.
They just keep their mouth shut and keep using it.
That's one way.
Put up tents.
Oh, the other, you were asking how did it even get to that point? That's one of the benefits, right? This is a 1988 case. So we have the benefit of that history of this issue having come up. And now we got an answer from a court saying, hey, in this situation, this is how, you can apply or resolve this issue. It breaks, left instead of right. And the zoning ordinance itself is going to also be an important point. So what was the language in the zoning ordinance about lots owned in common and how was it resolved there? Maybe there was no language and maybe now there is language. So there's lots of different ways that whether it's this community or a different community, how an issue ends up, the question is unclear. And so we're gonna have to ask the court to tell us, which way. The example breaks. So here we have another self-created, example. The landowner purchased property, with the knowledge that it was zoned for agricultural use. He thought that, he could use it for residential users, or I'm sorry, industrial users. Marketed it for 7 years, wasn't able to get any interest. And then applied for a variance for residential development, so a use variance rather than. A dimensional variance, because he wanted the residential use. And it's an interesting case, because query, okay. Just having the zoning one way is not a self-created hardship, right? We covered that fact, there was another case on that, but. Here we have two different zoning districts, it was agricultural and it was industrial, or at least he was marketing it as industrial. And now he's asking for a variance for residential use. So, how does that play into the background and whether or not it's going to be self-created? Here the court held it was still not self-created. Again, going back to, they purchased it knowing it was agriculture. And just having that zoning restriction doesn't constitute the self-created difficulty. And, then here we're getting some more facts too on looking for a 400 unit, 400 apartment residential development. Was something he wasn't able to achieve. So again, what is the scope of the residential use relative to the zoning? What is the amount of the variance he's looking for? Is it the minimum necessary? And we also then have potentially some of the market forces again, that he's marketing it and not getting any buyers or bites on a 400 unit complex, which was, let's say, permitted under the zoning ordinance. So now he's looking for a different type of use with a variance. And to get it to work for that area. So again, the way the different facts break for the specific property and the history of it. Can come to a yes or a no answer. There's also unique circumstances language, and here we're thinking about the property vis-a-vis the general neighborhood or the district. So that there's unique circumstances at play doesn't mean that they're exclusive or this is the only place they're found in the township or in that zoning district. So let's say wetlands or that pond, right? So wetlands are going to be found in other areas of the township and likely other residential or ag zoned property. But the way that wetland impacts that parcel may still be unique. For example, if the wetlands are essentially a pond and not just a certain type of soil composition, that may create a different type of practical difficulty. Instead, it's not, is there any other wetlands that are shared by others? It's that the hardship is not shared by all others. So I might have had that backwards. So the language is, and let me just read it because I might have got ahead of myself. So the courts have repeatedly emphasized that the hardship to be unique is not shared by all others. So not only that property, but it's not everybody in that zoning district shares that hardship. That's what's making it unique. So there can be some others that have it, as long as all others don't have it. Yes.
There was a situation like that up here on Elk Lake. Whole bunch of homes built down on the water.
Mm-hmm.
This one man, he owned that property forever, worked in downstate, made good money, kept it up. Came up here, wanted to build out of this and do it. What? People on top of the hill had a sewage disposal type thing for some of these people who pumped it up there. That water runs down under the ground, under your piece of property. Oh, boy, that hurt that guy, cause I know personally, I talked to him. And a year or so later, he had a heart attack, and he still had that property, couldn't build on it. Well, he found that if he drove piling down in the ground to the hard pan, he could put his footings on top of these pilings and build his highest house. Now, what you're just talking about is the whole situation with that person. And the township didn't understand what else he could do or never told him. But he found out and he did. In fact, 2 more houses there.
So, yeah, this is a really interesting situation. So you've got, you're mentioning there were some sewer issues with some of the surrounding properties, how it was impacting his property. And then the topographical situation of, you know, can he get the footings down for proper foundation and strength? So, there are some unique circumstances there, right? Maybe the way the sewer operation, you know, impacted his property, maybe his neighbors more so than others. Maybe that was unique. But the soil conditions were not, right? Maybe this area, being close to a body of water or what have you, is largely wetlands. That could be a reason to deny the variance. And then you said something very important. He put these pilings down and he discovered that he could in fact build if he built it in a particular way. That's new information that maybe there then isn't even a variance needed potentially, because now, oh, we didn't think we could build in the center of the parcel, which is why we requested this dimensional variance for the setbacks to get on higher ground or what have you. But now a different construction method actually allows him to build in conformance with the zoning ordinance. Or this additional information changes the calculation of some of those criteria. And that can happen as well. And it's not, again, on this body, although we'll have hopefully some time to touch on it in another example we have. It's important. And the MZEA is structured that members of the community serve on this board, right? This is self-governing, this is local governance, that's what we're about. So knowing the soil conditions in the area, you're gonna know that as a local community member. I'm not gonna know that as an outsider. And you bring that perspective here and you can bring that knowledge to bear on whether or not something is self-created, let's say, or whether or not it's unique. A court reviewing this isn't gonna know, you're gonna know. So you can bring that to bear, but it's also the applicant who has to bring you the information that shows this is why I need the variance, this is how and why I satisfy these requirements. And it may be the case that in 1 year, he can't. It doesn't look unique. It looks like this is widely shared amongst other property owners. But then maybe something changes, he learns more information, brings the same request. It might even be granted because there's now more information we didn't know that changes the way the factors are evaluated.
It could be that technology has changed, whereas it could not be done within the zoning requirements before, but now there's new technology out there that says it can be. It's, you know, and he has the responsibility to bring that to the board and say, look, you know, we really can meet the standard now.
Right, correct.
Things like that, right? You know, not that one.
So again, without knowing, of course, the situation you're talking about, but if, again, we have this sewer issue from the neighbors, well, if his building was gonna disrupt that, now that might be a severe adverse impact on the neighbors and a reason to deny the variance. But if there's new technology that allows him to build in a way to not disrupt that existing issue or to otherwise ensure there is no substantial adverse impact to the neighbors. Now he's been able to solve the issue that was identified and clear the criteria. So that is possible.
I didn't mention anything about any sewage because I knew it was in some people's mind in this room.
Or did I make it up in my own?
No, you done great. His son was quite upset over the situation, went ahead and already made arrangements for that piece of property to be pumped up on the hill in order to dispose of this, but I didn't want to say it at the beginning.
All right, well, I hope everyone out there is following the rules and taking care of what they need to take care of. So that's fine. So a property can still be unique, even if it doesn't have a physically defining characteristic, such as size or topographics. Everything we just kind of talked about was a good example of that. Again, as we sort of thought of the shorthand of, is it self-created? We want to think about affirmative acts of the property owner or the folks who owned it beforehand with uniqueness. We want to examine the land itself, but we're not limited only to that. And again, that's why you'll see the interesting cases like that come. It's going to be, hey, this is, X or Y reason why we think we need this variance or why it makes it better.
Okay, so I'm gonna talk a little bit about appeals from ZBA decisions, and we do see. In our line of work, we see township decisions get appealed to the court. And it's not something that I'm gonna talk about to be scary, but I think the amount that we see, we sort of get an insight. It's a learning opportunity for how courts think about what they're seeing. And so I think with that insight about how courts think about ZBA decisions or about township decisions in general, it can be really helpful to think about those things ahead of time. So judicial review on ZBA decisions is, I don't want to say limited, but it's a court is looking at whether there was an abuse of discretion. A higher must affirm the ZBA unless one of these things is true. If it's contrary to law, if it's based on improper procedure, if it's not supported by competent material and substantial evidence on the record, or if there's an abuse of discretion. So basically, the courts are saying these decisions ultimately should be made by the ZBA because you have sat here, you have heard all the evidence, you have heard all the public comment, you know the property better. And the court is wanting to affirm that unless, there's a problem because this decision ultimately should be yours. That means that a court could even disagree, like with any of these cases that we talked about. The court, an individual judge may have been thinking, I don't really know if that's a unique circumstance in my mind, but they know the property, they've heard all the evidence. This is what we want to defer to them to, as long as they show their work, say why they made these decisions, follow the proper procedure, publish notice, everything like that. A court ultimately wants these decisions to be made by you.
Question.
Yes.
What does a person do that paid taxes on a piece of property for 25 years and times have changed where he was gonna build before, she, whoever. And now the times have changed and they say they can't do that. How does the court handle that?
A situation where somebody wanted to build.
Yeah, they've owned it for years and they pay taxes on it, and then they move into the area and they want to build on that piece of property that they've been paying taxes on, and a township zoning board says you can't do it.
Like we changed the zoning in the meantime,
Pardon me?
like the zoning changed in the meantime?
Yeah, from the time he bought it.
Yeah.
From the time he bought it, yeah.
Well, then that would be a self-created problem that he didn't build when he could have. Now, the rules have changed and he can't build.
When you were 17, could you build?
If you had, the situation there is if you had something there that you built before we had the zoning ordinance, then you say, well, wait a minute, we're just replacing, and maybe now we have to make some changes because of the size or some. I think you have a case, but when you just sat there, just like what you discussed a few minutes ago, he created the problem by not building when he could.
No, he didn't.
He didn't build.
No, he didn't build, he didn't create that problem.
But he created the problem by waiting until after the zoning ordinances changed.
From the time he purchased that piece of property back in 1939.
I'm just saying, I think that's the way it is, the way we just discussed.
Yeah, yep,
Township
exactly,
changed it.
exactly, but that's still going to be a self-created hardship. If, and let's go all the way back to 39, you probably weren't doing zoning in 39, so at some point, a zoning ordinance was passed. And now there's setbacks that never existed before. That could have been, those setbacks maybe prevented building at that very first instance, with the very first zoning ordinance. There's still an argument to be made that it's still a self-created hardship because that property owner or their grandfather or whomever had the opportunity to build and didn't. And that case gets even stronger as self-created if the setback were changed in the last 10 years and I've owned it for 20. Well, then I had 10 years where I could have built and decided not to, and now the setbacks have changed. And now I wasn't even in a financial position to, because I was spending money on diapers and formula and not vacation homes. And now I finally can. But the setbacks have changed. Well, I had that opportunity and it's my desire to build the home and build the type of home I want that's in the need of the variance. So that's going to be viewed more as a self-created hardship. It's not the zoning ordinance modification that creates the hardship.
Then I should come to the board and then they deny me, I get an attorney to talk to you.
I would enjoy that very much. And the other thing I could do in that situation is maybe I do go to the board and I say, hey, you know what? You should create a different zoning district for these properties around the lake, because they were all platted in 1939 when it was a different size uses. Cars were smaller, there weren't the same density of population, and so the plat lots are smaller, and you've got 50 lots around this lake that are all gonna run into the same problem I had, because my grandfather was spending too much money on formula and beans and making sure we all survived lead paint. So you're gonna keep seeing this, create a new zoning district with different setbacks, or create a special provision that, okay, you're concerned about fire and public safety, well, what if I put in sprinklers, or what if I build with special fireproofing building materials? That then I'm advocating on my own behalf as, again, self-government for the board, the township board, who makes the rules ultimately by adopting the ordinance, to recognize that it is a shared problem. It's not a unique problem. It's a shared problem of this area that, if I can convince them that there's a technological change or a reason to modify the zoning ordinance, then that's a way to solve that problem. It's not a variance decision for the ZBA. It's a different solution of self-governance.
Yeah, we got some properties around here on the lake that. There's cliffs high up and down from the road to the lake. You gotta harvest the mountain goats, and we've had troubles before with property lines and structure. And that situation is what I'm getting at when I hear this stuff. I don't like to listen to it because right away my mind goes to thinking, how can we solve that? And then it creates hardship for somebody else. And the only thing I could think of then is you gotta hire somebody to come in township, take care of it. And I don't like to do that because I'm a resident, I've been here for a number of years. And, I make a lot of gut decisions and people don't like it.
So, right, 'cause you do need to show your work and apply those gut decisions to the applicable standards.
I try to.
And that will help, both strengthen the decisions and, help hopefully the public to see how you arrived at that decision, right?
Thank you.
And you're right, ultimately, every problem doesn't have a solution. Or doesn't have the solution the person wants or the preferred solution.
Better.
And, okay, I'm sorry, you can't do what you want. The answer is no.
Of money back. Thank you.
So, just talking about, how this looks practically. So when a ZBA is considering, let's say, a non-use variance, it should go through each of those standards, and vote on each of those standards individually and write the facts down on, each of those standards. Specific facts to support its decision. So if we're looking at a non-use variance, say somebody wants to build a house right up to the lot line, and that doesn't meet the setback requirements. You would first talk about, is this contrary to the public interest? Well, I think it might create a visibility issue, so I would say yes. And then you would break that in that standard and all your facts to support it. And me and Matt have this conversation because sometimes I'm writing something and it's so obvious to me. And he says, well, why? And I go, well, because blah, 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 blah. And he's like, well, write that down. I think that's like the hardest thing because you're in it and you think it's obvious, but voting on each of those standards and writing down your facts to support it is really important. And then you would go to the next standard. Is this a use variance? No, because they're still doing residential. They just want to have it dimensionally different. Then you write that down and you go on and so forth. So it's important to show that work, even though it can be hard because you're sitting here with each other and you're on your third hour and you think it's, obvious, but I think that that's a good, just to me.
Another point there is, you might come back to the same piece of factual information over and over again. For different pieces of criteria of, is it creating an adverse impact to the neighbors? Is it harmonious to the area? Is it consistent with the intent of the zoning ordinance? It might be, again, using this built right up to the second example. No, it doesn't promote the intent because the intent is to have open space. Yes, it does cause adverse impacts because there's going to be sightline problems. They're going to be right there, right on the edge of the district. And is there going to be traffic problems? The way the cars flow through, it's going to be right there blocking that vision. You're going back to the same piece of fact, but it's getting restated in against different criteria on why yes or no it's getting.
What if we don't? That's the right way to say this. I'll give you an example. Supply Road has 150-foot setback. We don't know why. We have no idea, nobody else does, none of our other roads. And we had to deny a request to come in 70 feet in that. It was right on a corner lot, it had to be back around 50 feet. But we said, well, wait a minute, you have 5-acre lot here. There's no reason you can't build. You didn't have to you've already taken the trees out where you're going to put this pole barn, which means I thought he was, you have the kind of like maybe we were real liberal, but there was no reason he couldn't meet the requirement. But we had no idea why he had to. The only thought I was talking with the county is that maybe that road would be widened out, but we didn't know that. But we had to enforce it. It's like, well, yeah. And I came back to the planning commission and said, maybe we could have tried to find out why. Maybe there's a good reason for that. Nobody knew. there was something a long time ago, but that had been canceled, that it was an endangered area or something. So, but that was all taken away, or beautification or something. But what do we do?
But I think what you're even saying there is a valid reason to write down. They could meet it if they wanted
Yeah.
to. And that's a valid finding,
It was.
I think that's perfectly.
But our problem with this is why? Why do
Right,
we
and then-
have this now? Nobody knows why.
Right.
Maybe conditions have changed, and we could, change that. That's what, we have some things going back to what, 1970? And we don't know why they're there. And yet, in some cases, yeah, they've given them variances when we, could say they shouldn't have. But on the other hand, we can't justify an ordinance. Why should we have it?
So that's.
You don't want to get rid, there may be a reason, but we don't know what it is.
So again, on the facts given, you did exactly what you should have done. You evaluated the variance ask as presented. Found that they could satisfy the setbacks and they couldn't satisfy the zoning criteria. Or I'm sorry, the variance criteria, so you denied it, so that sounds correct to me. At the same time, you saw this glaring problem. Why, this is an out of sync setback, the body to make that change is the planning commission, so you did exactly the right thing to go to the other board and say, hey, you guys need to investigate this. And then, potentially make a zoning ordinance amendment. Exactly, it's not a variance for this board to grant simply because there wasn't facts in the record of why the setback was that. That's not one of the, why is the setback what it is not one of your variance criteria. So as frustrating as that can be, it's about which group does which job, right? And here you look at the variance under your variance criteria, which is what you did. And the planning commission sets the setbacks by planning the zoning ordinance and hearing those concerns and sending them up to the township board, which is what you asked them to do.
You're ready, thank you. But thank you too. Brings up another question, you too. Why were speed signs picked up in Williamsburg here? From 25 up to 75 because it's not marked. Nobody said that anybody why that was done, except maybe a couple of people in the burg here. And there's no speed signs here. They were just taken out. And the county says that's a 75-mile-an-hour zone. That's not 75-mile-an-hour on Church Street. Well, things have changed. Well, the things that changed that I can see is signs call. I still drive slower, but nobody was notified as of why. We have to turn somebody down. Well, the county decided they're gonna make that road wider someday. I think today or tomorrow. Well, those kind of things is what we come up with.
Well, and that's why at the planning commission level, they have their own notice requirements. So when they're making decisions based on, okay, we're gonna decrease the setback, they would notice it and everybody would be able to come and give their input. It wouldn't be just something changing all of a sudden. So I think yours is a good point about that.
I think what they do is then push that off on the planning commission. They'd write it all up and lay it on the table someplace and expect each person to come and get one.
Well, it's about the separation of powers and which groups do which jobs,
Correct.
right? And here in this example, now we've got even more involved folks, because if you're talking about road speed limits and road control, now we are talking about the county and their authority.
Right.
And we have less impact as a township body on those pieces. And we can only do what we can do within our lane and advocate and raise the issue to the people who are responsible for that other lane.
The only explanation I ever got was, it's not marked. It's not marked, it's 75-mile-an-hour.
Yes, and I don't know what to tell you about that. I don't know what to tell you about that.
So. Okay, so I did want to talk a little bit about minutes. And I think that, you know, what's important about minutes is that the ZBA speaks only through its minutes. This means whatever decision it makes and however much analysis it does and public comment it hears, what a court will see if somebody appeals is what's in the minutes. If a ZBA deliberates for 5 hours and they go through every standard and they even vote on every standard, like how we've talked about. And then the minutes just say ZBA denied variance request. There's not much a court can do with just looking at that. So I think that while you're thinking about voting on these decisions and using factual support in the record, know that this is the only thing that a court is going to see. And also what your residents might see. I mean, what people who aren't able to make it to the meeting and they might come up and ask, why did you like deny this or this? And
What about the tape record or video recording of the meeting? Does the court see that?
usually not. I
So,
mean, there's,
yeah, it's gonna depend. Lindsay's right, usually not. Are they gonna wait through a recording of an event? There are ways that you could get it into the record, and that gets into the court, sort of the legal side of how you prepare a record on appeal. Can you create a written transcript from like a court reporter type idea? But to Lindsay's point, for a couple reasons. One is, if it's in the minutes, it's gonna be even easier to see, right? Even if I'm just an interested neighbor, I don't have to sit through a 5-hour recording to try and find the interesting bits. I can read the pertinent points out of the minutes. And then additionally, we're talking about properties that go back to 1939. That video recording isn't gonna be here in 2039. But the minutes are under a permanent record retention, so those minutes should still be here. So if there's a question for the ZBA in 2039 about what this body did in 2025, they should be able to find some answers in the minutes.
Yeah, and reading through the green books, they're very specific in there that when we give our yes or no answer, we're supposed to say why.
Yes.
Not just yes or no, but no, I don't approve of this because they don't think that, or I think they could have met there's no reason why they couldn't have met the variance requirement. That's what I understand the court wants us having our minutes. And I was just curious, we have recordings which go on, like you say, for 5 hours with a lot of discussion in there that really has no permanence, just people bringing it in. And you don't know what is the variance request.
Or, yeah, and even the end result, like you might discuss wetland conditions for an hour before finally coming to the conclusion that it is unique or it is not unique. And then that gets distilled into the minutes as, granted in part because the wetlands are unique.
Condition that was created by the owner.
This or that.
Series of national events, the water table raised or something. The road was put in 3 miles away. But those are the things you're supposed to say in your decision.
correct. Because that's really what a court and what your neighbors are going to probably be
But
looking
there
at.
are some that can be a strictly yes or no answer. Does this cause any problem to the health and welfare of the community? Well, no, nobody brought anything up at the meeting that said.
You just added
Yeah.
more. And nobody brought anything up.
Yeah, right, that's important, yes.
And we say
that,
there
okay.
no safety impacts.
All right,
Identified.
that's what I mean. Nobody brought anything up, so it says. Okay, you should say that.
See, and I'll
all
say,
facts.
we're lawyers and judges are lawyers, and we like to hear things a very specific way, and it's sort of like. It's unfair a little bit, because when a judge reviews it. a judge is putting then this legal landscape on you. But ultimately, it is what it is, and judges like to hear things and look at things a certain way. And I think all that we can do is to sort of have that in mind for making decisions.
Yeah, another way I like to think about this is. Going back to math class, and the teacher always said, show your work, and I hated showing my work because I knew what the answer was, and I just wanted to put the answer down. So, right, if it's 2 plus x equals 4, what does x equal? Well, x equals 2, but if I just put 2 down, I'm only getting half credit.
Yeah.
But if I do, minus 2 on both sides, so now you have x equals 4 minus 2, and 4 minus 2 equals 2, so x equals 2. Now I've shown my work and I get full credit.
It's like theorems in geometry, you gotta, in trigonometry, it's terms and one and word for where you go through the whole page.
Yep,
It's the
Mhm.
thought,
Wait,
right?
what is two?
to get one answer.
During that thought process and now the little math example is kind of silly, right? But when we apply it to these, there are gonna be things that are that obvious to you as members of the community of that topography or that area or the traffic patterns there, that yes, of course this is a hazard, or no, of course this is fine. But a third party, a judge, isn't gonna know that, so they need you to say it on the record for them, what everyone in this community knows. So that then, oh, that's why.
Well, and also you think about if this goes to the Court of Appeals, and then it's somebody not from near here, somebody in Lansing. Just looking at it, who doesn't even necessarily specialize in land use. They are just trying to look at. Decipher everything, and those obvious things that are very obvious to us need to be spelled out for them.
Can I ask a question, Lord? I'm the recording secretary, and your example of they deliberated for 5 hours and the minutes just gave a brief little blip. What about in a situation where, and this has happened before with me with different commissions and boards, where they just maybe didn't know the process or didn't do the process. I don't run their meeting, sorry, I don't run their meetings, but I record the meetings and the minutes. So those minutes may be very, maybe missing some things because they didn't happen.
So are you saying that they didn't deliberate for a long time, or they didn't make those specific?
I'm saying perhaps they didn't do the specific steps. It's
Not
just an example.
Not on you.
Yeah, but I
Right, the
also,
minutes will look like, oh, minutes are terrible.
yeah,
You know what I mean?
but even,
But then it didn't happen.
yeah,
The board's fault.
I don't,
right, and that's why we
I don't
do
manage that.
these types of presentations with a lot of boards, but even something like. So-and-so spoke about wetlands. This expert testimony presented this. But yeah, I mean, it ultimately is on the board to be thinking about everything and making those decisions.
And they're approving those minutes after that.
Right.
That as well.
Yeah,
But again, a lot of times they may not know or be aware that something major is missing in that process.
Yeah, so there's a couple different things. There's some things you can do as a recording secretary to assist process wise. And then there's things the board can do, and ultimately it's the ZBA that carries that responsibility. For one example, you could use written decision forms. You could have a template form that you fill out, and so now you're not relying just on the minutes. You have a written decision form, and you get used to using that and having a blank space for your because, and you're always giving the facts, writing them down in there. Another process potentially would be to have, okay, you have your minutes, and if there's a variance request and it's a non-use variance, you have the 7 criteria from each of those, you put them into your minutes. And then as the board deliberates, you're noting what they say for each criteria. And you have it in front of you in a format that allows you to fill it out, and you could even point out to the board. Board members, I didn't hear any deliberation on criteria number 5, which is whatever criteria number 5 is, adverse impacts, let's say. And then that prompts them to make sure they're, oh, yes, well, the house being right on the line is definitely gonna be. Negatively impacting both the traffic and the neighbors. Sight and sunlight and the shade, and so definitely an adverse impact being right there with the property line, something like
And I
that.
do pop in as much as I can or feel it's appropriate to. Say, oh, I'm sorry, but we need a motion for this or that, but there's a line too where I don't run the meeting there.
Correct. Which is so, and to the concern of it being a responsibility issue, it isn't. So there is no. Legal culpability, let's say, to that aspect. In the same way that we can only do as much as we can do for the speed limit on the roads. You can only do as much as you can do for what the minutes look like.
I just wanted to give it as an example.
Mhm.
That's something I've experienced in the past.
Yep, so there's a lot of different ways to do that, and then we've got some other examples too, and we've touched on it a few times here. When you say yes or no. Because, yes or no, yes, because the wetlands cover half the parcel. No, because they chose to be upfront and they have a 5-acre parcel that's very buildable.
With both hands.
But there's also consideration of too much information.
Right, there is, because again, the minutes are not a transcript. They're not meant to be a transcript. You don't need to transcribe and get every zoning member's comment on every single data point, as long as the salient points and especially the conclusions are within the record. That's going to be enough. And I think Lindsay mentioned it. An expert report showed that the wetlands were extensive. And that's part of the deliberation, so that's maybe one of your lines in that section of the minutes. Or the zoning administrator's report. Indicated that 7 letters were received against it, and they consistently talked about the declining property values. Whatever the different facts are, again, those are what's discussed in the deliberation. Whether they talk about one of those factors for an hour or 20 minutes, maybe you have 2 or 3 sentences for the hour-long one and 1 sentence for the 20-minute one, but you don't need 2 pages for 2 hours, so to speak. And what was my other thought? Oh, in the final motion, when it's crafting good motions. Will again, in a sense, repeat, just like you might repeat the same piece of factual data of wetlands or that's going to cause shadow or obstruct vision several times for several criteria. When you come to your final vote, you'll want to hit at least some of the key criteria that are in favor or against, if not all 7, so that you're saying it is granted because it's a uniquely shaped parcel close to the bluff and therefore has to be close to the road. Or it's denied because they have plenty of space and the issue was created by whatever their desire to be close to the road or whatever the case may be. And then you're even in the motion itself, which everyone should understand and should be well repeated, since to repeat the motion so that you make sure you get it correct in the minutes. You've got again some of those facts linking back, which again a court is going to love because they're going to see the exact decision that was made. They'll see those little pegs or points of information and they'll look back in the record. I will tell them to look back in the record, right? I'm going to make that point all day.
Yeah.
Waving that zoning administrator's report around, waving that expert's wetlands report around. Like this was submitted, this is what they relied on, and see, they talked about it here and here and here, and it was even in their final decision.
Yeah, it's the point that we need to reference better, all right? And we are a new, board. We've been exposed and been accustomed to certain procedures in a certain way. But we don't have to continue that, we can change and modify our comments, our speech, how we come to decisions and articulate those better in our, and that's the whole thing. And sometimes, sometimes we're not thinking, we're not thinking about how to make things complete. We're just going on, okay, we'll just vote, okay, he said yes, okay, we're done, okay.
That's
Why?
why I'm here. Could I say something else with regard to your point?
And I appreciate your comments, I mean.
Yeah, I do too.
We've only, this is only our second meeting, and the last one was January, a long time ago it seems, but. I really appreciated your comments at that point.
Well, thank you. And what you were saying about making more direct points, a lot of motions, I'm so sorry, it's okay. A lot of motions start out real nice and then they trail off into discussion. And I can't write a motion in minutes based on that. I'll often say, would you be more specific? Or some people say, I'm so moved, and it's like, what is your motion? But so many times you start out lovely and it trails off into a discussion with one person's own thoughts or multiple people. And that gets difficult. I can't do that, but if people are more aware of it, it's helping everybody.
Because it's important for the minutes, and so I always, when I'm taking notes, I hit them with, so what's the final motion,
And I will read it back many times,
Right, yeah,
in many instances, I mean.
yeah. So, and then I did want to just touch on, some of the benefits and, considerations about strong decisions. Upholding ZBA decisions is good for the township in multiple ways. One, it's upholding what the ZBA and what the planning commission and what the township sees for the township. What its goals are for the township, it's upholding those decisions. And then also, when you have consistently strong decisions that are being upheld when challenged, it creates a reputation of this ZBA makes its decisions right. It's not just everybody can challenge anything. There gets to be a reputation, and I guess a reputation, I guess, is the best word for it.
Yeah, and it creates that, it strengthens the community as a whole, because there's now a sense of, oh, we're being governed well. We can we can be proud of the decisions of our ZBA because they're being upheld, which means they're following the rules, which means they're articulating their reasons. I may disagree with you, you may disagree with each other, but you're going through the process, you're doing the civil engagement of sometimes very difficult decisions and coming to a final answer. And we can be happy about that.
And I think just, some of the checklist items for making sure that those are strong decisions. I think thinking about, okay, did I follow everything in the zoning ordinance and in the MZDA? Did I notice everything? Is this something that I can decide? All of those things. And then being impartial to every property owner and to following conflicts of interest. If you have a conflict sitting out, making sure that those procedural steps are made. That could be at the beginning of a meeting, a spot for anyone to declare conflicts of interest, or even involving township council. Sometimes we make those calls to individual members so we can screen ahead of time and really know that nothing is going to come up in the future. Making clear decisions that are in the minutes. I think everything that we talked about before. And then asking questions of experts, not, engineers too, but also legal counsel. A lot of the times a quick phone call or asking us to do a screening of something will save a lot of trouble and unexpected things. So I guess this is sort of your checklist of questions. Do I have the authority to consider this? What can I point to in the zoning ordinance in the MZEA that allows me to do this? Did I follow the proper procedures? Okay, did I publish notice ahead of time in the newspaper? And then did I do my 1 day notice ahead of time as well? Did I check for conflicts of interest? Did I make these factual findings on the record with my because? And then, if there was anything wonky or anything weird or anything I didn't know the answer to, did I call my township attorney?
Can we call you?
Yeah, of course,
I mean, we have a question during
Yeah.
the meeting, okay?
we answer stuff
I didn't-
all the time.
I didn't know that.
So, yeah, and there's. Every community is different. There are some communities we attend to every single zoning ZBA meeting, cause it assists them and it's beneficial to their members. Sometimes we'll take a call in the middle of a meeting. Usually we'll be given a heads up that, hey, X and Y is, there, and they might have a question on, A, B, or C. So if I don't know what you're dealing with in your meeting and I just get a call, you're gonna get an answer like, well, I'm gonna have to look at that, and then you're gonna have to adjourn for make a decision at a next meeting. But as a ZBA, you also want to make sure you're following your internal procedures of, is it the zoning administrator's responsibility to flag those issues and reach out to township council? Or is it the zoning administrator's responsibility to flag that issue and ask the supervisor, and then there's a conversation with township council? So how that works, again, is gonna be different in different communities and what your needs are.
Maybe we should have that in our charter. My question on specifically, talking to legal, my feeling is that if I want to talk to you, I really need to talk to him. He's the chairman. I should not go behind his back and ask you something, even inadvertently. And if I talk to him and he says, well, I don't think you ought to do that, I'll abide by that, because he may know things that I don't know.
Right.
So I don't think we should individually ever do that unless there's something really funny going on.
Yes, and I would agree with that. If I had, 5 members of the ZBA all calling me with the same question, that's not an efficient way to answer your question. And to your point, Carl, that maybe he raised that with the zoning administrator and she's like, oh yeah, that is super confusing. I've got a whole section of my report on it. And if that's enough to answer your question and you're able to arrive at a decision, that's great. If you're still left without feeling confident, then maybe you vote against it or seek to table it. Maybe the rest of the board got enough information, they feel confident enough, right? Because again, you've got those differences of opinion potentially on the issue. So there are lots of ways to deal with that. Certainly, we can and will assist, when needed. And it is important, we had it here, it's really here twice. Use and rely on your experts and rely on legal counsel. I like to think I'm an expert, although I do also know my limits. But the experts come in various forms. You have a zoning administrator here who's gonna gather information for you and present it. So, and Lindsay's exactly correct. Was it published? Was notice mailed to folks? Well, that might be a statement right there in the zoning administrator's report. So then it's something that can be noted at the beginning, right after the close of the public hearing. You've got all your information. And you're like, okay, we're considering X and Y. The zoning administrator report shows that it was, put in the newspaper and that it was mailed. We haven't heard any complaints about a lack of notice. And right there, you're covering some of your procedural bases by having it in the record and then just touching on it as you go by. As mundane as procedure can appear, it can also be important and material to whether or not a correct decision was reached. So if there's a question on any of the points going back to an expert, whether that's another township official or a zoning administrator or an outside expert like an engineer or a environmental specialist. Use those experts. Make sure you have the information you need, or potentially it's the applicant's job to get more information on. An impact that their proposed project would have and the variance or the appeal. If they're saying the ZBA, the zoning administrator made an incorrect determination, maybe they need to bring additional information to you as well. But there are all resources for the ZBA. Okay, so we want to hit on a few other kind of esoteric areas, and this also reminds me of another interesting point. The ZBA, different from other boards, has alternates. You have the ability to have an alternate sit, so you know whether you can make a meeting or not, that's an option. If there were a conflict of interest, you could have a member step away and then still have a full 5-member board. So that's a great. That's a great option that is available to us in the MZEA. And can make certain procedures and things easier in sticky situations. There are then other additional off ramps, right? When we get into really sticky situations. So this is the rule of necessity. This can occur if there's a significant conflict of interest, like a project is going to impact the community very broadly, and it's very hard to say anyone really has no self-interest in something. Essentially, if everyone has a conflict, then we disclose it, we put things on the record about where the situation stands, and move forward the best we can, and then there's some guardrails within the statute as well. For example, this 25 hours per week piece, and it really does disqualify at least a quorum, if not more. So it's only going to come up in rare circumstances. So here looking at an example, and if it were a smaller ZBA. If you've got a company coming forward, you've got 1 of 3 ZBA members holding an interest in the company. The ZBA still can vote because there's a quorum, but the one interested member recuses themselves or potentially gets replaced by an alternate. Rule of necessity doesn't apply if we only have a conflict from 1 or 2 members, right? And another thing I want to make sure to point out, the alternate would sit for the entire meeting. So it's not a swapping situation where if you have 2 variances and I'm bringing one of them and I'm related to one of your ZBA members, that she hears the first variance and then leaves for the second half of the meeting, and then alternate comes in. I know that we're going to have the same board for the entirety of a meeting. Another rule of necessity example, ZBA asked to review a variance from FSBR for a lesser setback. 2 of the 3 ZBA members now are employed by FSBR, being an outstanding company to work for. One, let's say, one might even be a township trustee, and that's how they're on the ZBA. No alternates available. So if we satisfy the other requirements of the rule of necessity, if it's a 3-member ZBA, you've got 2 members conflicted out. Now we do have a rule of necessity issue because there's no way to address legitimate business before the ZBA other than using that exception. We also, as we said, have Open Meetings Act obligations. All of the ZBA meetings are open to the public. The key criterion that I want to make sure I hit on is the deliberation and discussion of actions that come before the board. So with that means any decision or deliberation on a decision must be in an open meeting. That's as to a quorum, so two of you may meet up and say, oh yeah, I saw we got the packet, oh, what did you think about, were you able to understand the environmental report and the wetlands? Oh, yeah, I did, mine was in color and it looked like this, oh, mine was black and white. So you're kind of deliberating and you're talking about the packet, but it's just two of you, it's not a quorum, so that's gonna be safe, that's okay. Also there, you know, you're trying to get on the same page in terms of where the information is, not. I never liked Mr. Jones and I'm gonna deny the request because I didn't like him, I never liked him either. Not so kosher doing that. Three members together, now you've got a quorum, now you don't wanna be discussing. ZBA business.
I have a problem with what you said. If I'm talking to her about it, I have a duty to tell the other members that we talked about it. I think that's in the green book, that I shouldn't be sharing information with her and not with these people before the meeting. If I have something relevant, I mean, if it's opinions, that's one thing, but if I said, hey, I just read this report and it says this, and look, here's a copy, I have to give everybody that. I believe that's what the rules say. I can't just talk to one person and give them information that I don't share with the other people.
Yep, so great point. It's not gonna be an Open Meetings Act violation, so that's good. Your bylaws will play a role here too, is, you know, if that's a policy of this body and what are the expectations amongst the members to each other. That's important to uphold. And it also highlights the different role of the zoning board of appeals. How you're different from the planning commission and the township board, since you adjudicate these appeals and adjudicate these variance requests. It's more, it is, I don't wanna say more important, but it's a different quality to ensure that all the members have the same information. Unless your bylaws say differently, I wouldn't say you have to, you know, disclose the entire conversation. But to the substance of what you're saying, I believe is correct of, you know, that is a really great point, or this factor that I found. And then to bring that up with the rest of the board of, you know, I saw this in the packet, or, you know, I know something else about this property and I was talking to, you know, the clerk about it beforehand, and I wanted to make sure I shared that same insight with the rest of the board.
I think the one thing that you have to be careful is the Open Meetings Act game of telephone, where one person says. Talks to one person, and this isn't an Open Meetings Act violation, but they're saying, I'm gonna vote yes on this, okay. And then they go to the next person, it's two people talking again, okay, me and so are gonna go vote yes on this, and then it goes down the line, and really, that's not in the spirit of the Open Meetings Act, so you also have to be careful. Even if it's only two people talking, that you're not sort of creating this chain, you know?
You're not voting.
Right, yeah.
You're not polling people either.
Yeah, so
Behind the scenes.
lawyers sometimes will say, right, oh, as Lindsay pointed out, it's only two people, it's not a quorum, well, you're too smart for your own good, right? And the court's gonna say, nah, you talked to four people. That was deliberation, so she's right, it's important to do that and be aware of it. It's also, with technology, we can run into it when we don't mean to, replying all on email, now all of a sudden. That's 4 or 5 people talking together and potentially deliberating on the quality of the application, or what's a question about this. So being careful with your technology pieces, phone calls, text messages, emails.
What about talking to the homeowner before the meeting?
You can talk to the homeowner before the meeting, they can talk to you, again, I've seen some communities where they put that in their bylaws where. They can go and view the property and sort of get a feel for the place, but they're not supposed to talk to the homeowner, again, on this, given the adjudication sort of. Position, they wanna structure their body so that It's sort of like a court proceeding where all the information comes out at the public meeting, everyone who's here gets the same information. So there isn't, oh, I talked to them beforehand and they told, you know, me this, and then they told Roberto something else and told Skip something else, and now. There's different pieces of information given to different folks. But generally, I would say it's not a problem, you can talk to the landowner and then you do what Carl was saying, you say, yeah, when I went out there on Thursday, I talked to him and he was telling me about how all the frogs were always out here and it's definitely a wetland, even though it doesn't look like one, so that's what we talked about. And now you're disclosing it, it's all above board, there's no.
One of the things I was cautioned about, and I believe it's in the green book, said. They really don't want you talking to the, listen to the owner. Do not give him any information, because then if he comes to the meeting and it's, everything is, you consider is supposed to be in that open meeting. Not information you got from somebody beforehand and nobody else. So when he says, well, you told me it was gonna be okay. Or you said, green wouldn't be a problem, but then you get in a meeting and everybody in the neighborhood says, there's no way we want a green thing in our neighborhood, but. But you promised me, and then, that's what I say, you don't offer them opinions, like when a board member talks to voters. That's okay, and to an extent with on the planning commission members, it's a little similar, but you can be a little more open on it, and this you have to be very, because we're a judge.
Right.
You don't wanna be representing as one member of the board, yeah, you're probably fine with
Yeah, I'm in a little bit of a.
right,
Once I have the board in the, especially, we have to be careful. That I get blasted all the time and by a couple of people in the township, and I don't care.
Right, I mean, again, yes, that you're generally correct, and there is a difference between the landowner or the applicant talking to you. While you're there visiting the site or because you ran into each other at the supermarket versus. You as a ZBA member telling the landowner your opinion. When you haven't seen necessarily all the information yet, even if you've gotten your packet and you've gone through it. Then they're getting a misformed idea of what's gonna happen. You may end up voting consistent with the opinion you told them in the supermarket, which may be different than the other 4 members of your board.
But
it creates that.
Yeah, now it's go out and look at the property twice, so. And especially after I've gotten the packet and maybe go back again and look at it and. But. It's. You gotta be, us. And there. We received one extensive email from from the person wanting the variance. Telling us all kinds of stuff, in an email and in a letter, and they're not supposed to do that, that's not, you can do that to the. Planning commission and the board, but you don't do that to the CBA, we're not allowed. To be getting something from somebody and reading it before the meeting, I've had, people call me and they wanted to. Put a letter or something at a particular issue, who do I talk to, and I said, bring it to the meeting. Don't send it out to us individually, we're not allowed to look at it, only what's presented in the meeting. And some people don't understand that.
Yeah,
The rules for the ZBA are different than for the other branches, we're independent, and that's our rules.
right, the ZBA is a quasi judicial body, which is different than the planning commission and the township board, which are legislative bodies. And planning commission more of an advisory to the legislative body, but right, it's a different character, you have a different lane that you're in. Potentially hearing these appeals on decisions the administrator made, or trying to figure out the factors on a variance request. In those types of situations, I would just forward the email to the zoning administrator and say, please make sure this is in the packet. And then you can consider it, you can read it and you hear what they have to say, because the landowner also.
I disagree with that, because the general public isn't getting that same information at the same time. Well, okay, it's in the packet, but do people read that before the meeting, or it's presented at the meeting? Now, I just assume, don't tell me anything about it until we're there. In the open, you know, you get accused of all kinds of things. So the other thing is, our decisions were final. The board and planning commission can't override us.
That's right.
We have to go to court, and that gets messy.
I don't wanna suggest that you should. Change the way you're approaching that situation. I think it's fine if you don't want to read that email. In this situation. Another approach is. Okay, you forward it to the zoning administrator, it's in the packet. And if it's really compelling to you, then again, that goes back to creating your decision and you say. In the packet is an email from August 1st, where the landowner says, the reason this is a unique hardship is X. Or the reason that I'm gonna make sure how I'm gonna not impact my neighbors is Y. And that to me was very important, which is why I think they satisfied this criteria. So I understand what you're saying. And about any information in the packet of did the public really understand this? That's when we build a good record by highlighting it in our deliberations, and then we'll get that in the minutes and or maybe as well in the motion itself. And then you're making those connection points so that it's clear if someone does want to know, one way or another, why did you make the decision you made? Well, it's in the packet and I talked about that information and I told you why I thought that was important. So it's all right there. Even if you forgot why you voted for that, you can go back. Just to make sure we hit the other pieces of the Open Meetings Act here. Shockingly, open meetings are open to the public. Public comment occurs at every meeting, so we've already had some public comment. Which is good because these types of meetings are a good example of when we can sometimes forget to do public comments. So, oh, we're here for a training, we're just here to learn from the attorneys. It's not a real meeting. Nope, still a real open public meeting and we gotta have public comment. So we've already checked that off. Having your notice and doing your minutes. All things that are gonna be helping keep you compliant with the Open Meetings Act. The Freedom of Information Act, right, the FOIA is also going to apply. Is again, a township body doing township business, so again, those packets are open, they're public information, even, they might not be posted on our website. But that doesn't mean that folks can't get the information. We're working towards disclosure and transparency. And also, to the question about emails. If there's a FOIA question, those electronic communications, again, technology can also be part of FOIA, even if they're emailing you into your personal email. That may be a public document if they're discussing township business on an application that they've submitted. And then, you'd want to forward that to either your township email if you have that, or again, forward it to the zoning administrator and say, hey, this is a public communication I received. So now you don't have to worry about really your personal email if it's otherwise not used for township business.
And Wendy, you're the FOIA coordinator?
I am.
Oh, always for you. And there have been, I don't wanna get too into the weeds on FOIA, because it's kind of off the path here, but. That's the other side of technology is good when we have more information available on the website, and then it's easier for the public to have access to things and. So it's a plus, and technology is a double-edged sword, I suppose is where I'm going. So now we have a couple examples that we can go through. So in this non-hypothetical, because we drew it from a case, so it's at least mostly accurate, even if we tweaked some of the facts to make it a little more interesting. So 2018, property owners purchased a house in a community, in a historical community, and started development. That started development since the 1800s, so buildings have been here for a long time, right?
Like this one?
What's that? Yes.
Sure does.
The character of the community is considered to be historic, and the zoning ordinance seeks to preserve that historic nature, right? That's an important point for many of our communities. The home of the property owner they bought was built in 1861. Although most of the community composed of homes from the same period, many of those homes in the immediate vicinity were built closer to the mid 1900s, so almost 100 years later. In fact, most homes surrounding the property owners were larger and more modern, so they'd seen some renovations. So that's the scene. In 2023, 5 years after the homeowners purchased the property, they wanted to expand the home because they had a daughter with special needs, specifically cerebral palsy. The property owners spent a significant amount of money developing plans to enlarge the home to accommodate those needs. They are looking to expand from a 1,300 square foot living space into a 22,850 square foot living space. To accomplish the expansion, the property owners realized they were required to obtain a variance because the expansion is going to encroach on the 25-foot front setback requirement within the ordinance. So they came to the ZBA and requested a variance. Public hearing was conducted, and the following evidence was presented. A letter from a real estate broker, which stated that alterations to the home would increase the property values of the surrounding properties. A letter from the Historical Society, providing that the renovations would not change the character of the community. Letters from 10 neighbors that opposed the enlargement. Various neighbors providing public comment, both for the variance and the expansion and against. Site plans demonstrating the proposed expansion along with all other necessary paperwork. And medical records demonstrating that the daughter did in fact have cerebral palsy, which would be, well, it's an important basis of the request. So that's the salient evidence, no other evidence presented to the ZBA. So if this is in Whitewater Township, the same set of facts, our criteria are. Is it not contrary to the public interest? What's the public interest? What's the spirit and intent of the ordinance? Is this creating an established use not permitted? Is it causing significant adverse effects? Are there practical difficulties on the site, unreasonably preventing the owner from doing the permitted purpose? And the practical difficulty doesn't result from the applicant's actions. The variance will do substantial justice to the applicant, but the decision does not bestow a special development right, nor result in substantial adverse impacts. The requested variance is the minimum necessary, and the practical difficulty is not self-created. So now you must decide whether the standards have been met based on the evidence presented. And if the standard is met because or not met because. Yeah, so then I'm gonna go back to the evidence. And I'm wondering, before we move on through the slides, what the initial feedback is. I know you're just seeing this first blush. But kind of what's the feeling of different board members to different pieces of evidence? What jumps out at you?
What jumps out at me is, the first thing I wanna know is, can you get a fire truck down beside the variance that they wanna be in?
Great question. Yes, you can. Still able to get fire trucks through there.
Okay. The three of you lived in that house at the size it was before, I think you cut the size of the house down.
Right, so comments on, they were there, what, 5 years? Before the variance is requested,
Well, to
but do they need that size?
me, that would make a difference. But if they can get by with a smaller house. That's what I'd be looking at.
Because then it would be the minimum variance needed.
I don't know.
And, yeah,
It would be denied. They don't, as I said, they probably don't need that big of a, they haven't demonstrated, even though of her condition, yet why she needs a bigger home. They can always go and buy a bigger home. Maybe, you know, this community, I don't. There's some communities where when you have these historical places, it's tough. So I would say it'd be denied, and I think the Michigan state course I took, I had a very similar thing. And I wouldn't granted it until I read the opinion.
Other thoughts?
But we don't know if they can go out the back or other way, right?
The spirit and intent of the ordinance, is there historical concepts in that? Like, is there restrictions in that? We didn't hear that part, right?
Only if you have a zoning district.
There
that defines
would
it.
be,
No,
We don't have it defined in our ordinance.
oh, right, but in this instance, is there a historical community that
yeah,
has an
character,
ordinance and?
character of the community is considered to be historic, and the zoning ordinance seeks to preserve that nature.
Therefore, the spirit and intent of the ordinance, that might not be keeping in that.
Is it the variance is for the front setback, is the variance going to impact the spirit? Or merely the development, the expansion of the home, because some homes are larger and more modern in the district.
Do they have variances?
No,
So what is the setback?
It will be
Not, we've got a setback.
25 foot was the setback, but yeah, I don't think they told you what the variance was.
The setback is okay?
They're not meeting the setback.
No, they're not meeting the setback. Why are they asking?
It's a good question. I don't think we have those setbacks. Let's say we want to make something up 10 feet.
No.
Yeah, let's say they're asking for only being set back 10 feet.
25 foot requirement. So it would be 15 feet instead of 25 feet.
But every other house on that street is not 25 feet back.
It would
I
be.
don't know.
Yeah, that would make a difference if I was.
That's a lot.
Okay, that's interesting.
Yeah,
A good zoning administrator would make sure they make it smaller, but still accommodate what they needed.
yes, good thing we have.
So potentially, right, because it does get into more of the application, but if you have, right, so the daughter here has cerebral palsy, that's one of the big driving factors. So they have
That shouldn't be our driving factor though. So.
is it though, because so this individual then, they could have more square footage to have a separate kind of living space with a bedroom and a living room. And that would allow the daughter to have more independent living while still remaining with her parents and getting the care she needs and then being able to remain close to each other. So the practical difficulty, we're thinking again from a zoning and land use perspective. You know, that's not self-created, this is a unique situation. From this medical condition, the land use itself is still residential. Yes, this is expanding historical. But there's not, well, there's evidence on both sides about how that impacts the nature of the community. On one side, other homes are enlarged within the community and they've been modernized, which is arguably what's happening here. But then you have neighbors saying, no, this is gonna be different in character from those other expansions. Right, so how do you weigh, some folks are saying it will be in harmony with the adjacent homes. Because there's larger homes, others are saying, no, this is gonna be different. So you've got evidence on both sides there. And you picked out some of the things that we had here on the next slides, right, of the size of the expansion, is that really necessary, that much space? And have they justified the need for that much space? And again, the tension between the historical society and the different pieces of evidence there. And then the property values, right, was evidence submitted that it would increase or not decrease the value of the neighbors as well as the direct parcel itself. And I think the variance is ultimately, the variance is a important consideration as well. Which again was teased out very well by you members. Well, how much of a variance from the 25-foot setback are we talking about? And then, where's that gonna be to the road? Is this more of a walked community? Those types of impacts. Because ultimately, we're not building the house. That's not our job as government officials to judge, those choices. Is the zoning ordinance worthy of being varied here? Does it meet those criteria? So, good discussion. My slide here, again, we've hit on a bunch of these facts. Things could be obvious, but not always. So we can disagree, we can emphasize the facts that are important. And I think it's met because X or Y. So this case came out of Grosse Pointe Farms, and here the ZBA denied the request. And it hit on the key factors and points that several of the board members raised. It did seem to interfere with the neighbors more so than other improvements, and there was a hardship, right? So some factors were satisfied, but was it the minimum variance necessary? Did they need that much more square footage from 1,300 to 2,850?
Almost, or more than
More than double.
More than double, exactly. So you might even, again, to the point I was making, it may be possible to give her that same independent living, but scale back other portions of the expansion in a way, or orient it in a way that negates the need for the variance. And then the Court of Appeals affirmed the decision, and the other thing that makes this interesting is that they noted the evidence on both sides, right? So here, the variance was denied and the Court of Appeals affirms, stating that decision was not without evidentiary support, right? So they also saw all of these other reasons for granting the request, right? And we got 4 bullet points on the right, 3 bullet points on the left. But the court is still affirmed this decision because there were 3 good reasons. And that's what they're looking for. As Lindsay said earlier, the court doesn't really want to come in and be a new zoning commission, be a new planning commission, be a new zoning board of appeals. At least they shouldn't. Instead, they're deferring to the local communities and deferring to the decision making, as long as, again, proper procedures is followed. We've checked all the boxes on the elements. And then get an affirming decision, even though, like, again, as Lindsay said, maybe some of the judges would have decided it differently if they were sitting on the ZBA.
Yeah, I think that maybe if this case is interesting, a lot of cases are like this, I think really the ZBA could have decided the other way and probably got affirmed too, if they showed all of those reasons why they think so, it's just about showing those,
Right,
yeah,
I'd like to comment on that.
yeah.
I wasn't there to see the property.
Mhm.
And as you were reading it, sounded awful familiar to me. There was a request to put a walkway there. Can you hear me? There was a request to put a walkway down the north side of a house. So one of their family members could get up in a wheelchair and get down there.
Mhm.
Well, that's fine. They're gonna be too close to the line on the north side. Quite an argument about it. But there was a ditch. There was a ditch on the line to run the water down towards the lake.
Mhm.
Well, I voted for that because there was lots of room on the south side to get a fire truck down. And instead of adding on to the house with more expense, they could use that interest that went into the house that was already raised. And it sounded awful familiar, but not having seen it and talked to the people, I couldn't answer this one.
Mhm. Yeah. There.
yep, and again. There can be differences on even the same record.
Just waiting for Wendy, I wanted to just interrupt for a moment, we've hit beyond the 3 hour mark of the meeting, so a motion needs to be made to extend the meeting. I thought Wendy was coming back right now, but,
It's 9 o'clock now.
I just wanted to make that
Yep.
note that a motion will be needed.
I think it's been an excellent meeting. Can you hear that?
I can.
I think it was a good meeting.
I don't want to interrupt you.
Yeah.
Riddle.
That's a good point.
Would this then be continued at another date or? Was we still haven't finished
Right, so
the
the,
agenda.
yeah, so the point was made that you're at your 3 hour mark of, so whether or not you'll continue the meeting, given that you've been in it for 3 hours. We are near the end of the presentation, so for the board's benefit, if we can wrap this up and move through it quickly and then finish up with the rest of your agenda, but given the procedures, it's
Maybe vote on this then.
right.
I made a motion to extend the meeting past the 3 hour mark.
I will second that.
Roll.
No, I do not support that.
I'm sorry, who seconded that? Roll. Okay.
Carl.
Yep. No, I will, but roll. Yeah. Some of you sound alike.
What?
She's got it.
Oh, I.
Yeah. So now we need a vote.
Yeah, so the motion is made and seconded to extend the meeting beyond the hour mark. Is there any discussion on the motion?
Why don't we get it done?
Yeah, not,
Alright, so
I'm not sure.
if you want to extend it, how long?
Yeah, I have a limit on my hearing aid batteries. I don't know what it is.
No, we don't have to
I,
check how long, but let's wrap it up though.
I would go, extend for a while longer, half hour or so, but not till 11 o'clock like we did the other night.
Right. You have to determine how long in this.
No, we just need to keep going right now and then wrap it up.
And then you could table other things if you decide this is it. We're gonna adjourn, table this, this and this.
Mhm.
Right now, just a motion to extend it. And then it's ready for a vote. We have a first and a second.
Otherwise, you have to start this meeting back over and continue.
You could, yeah, well, there are lots of options. You could adjourn, schedule within 36 hours.
Mhm.
You could end the meeting and then just begin a new meeting.
Begin the new meeting at another date.
Right.
Well, we need a.
Any other discussion?
I think for an extended meeting, I mean, certainly beyond 3 hours. I think it's beyond some of our some of our capacity for attention and involvement.
How much longer is your presentation? This is why we started at 6.
Yeah.
We have four more items on the agenda.
Right, those could be
Then
fast,
we could defer those.
right,
We could defer the meeting.
yes, we can
Yeah.
table those.
Table those for the next meeting and finish.
So,
Yeah, we'll wrap this up. I didn't, I can't see the clock here, so I didn't know how long I've been running it on. But yeah, we'll get you wrapped up.
right,
So then we need a
so
voice.
you wanna reword that motion?
No, it still has to be the same. It's the motion was that we are gonna extend the meeting beyond the 3-hour mark. We're already there. So if we had to stop at 9, we should have already stopped. But now we're extending it past that.
I couldn't see it, I can't
Yes,
see the
it's
clock.
9:13, so then,
I'm sorry about that.
yeah, it's okay.
Sorry that I
Voice
wasn't paying
vote.
attention at the time, I can't see it.
So we just do a voice vote
Yes,
to say yes or no.
So all those in favor of extending the meeting, say aye.
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 All those opposed?
Yeah.
Motion passes 4.
Right, 3 and 2. So, yeah, so let's get on with it.
Okay, so we
Talk about putting pressure.
Right.
If you've got the, keep it efficient. If you've got my handout, you've got some of these additional, examples, which we did cover some earlier, and they just give you some additional information. Here's our, self-created hardship example that, also involved a variance that was granted and then not acted on. As I kind of hinted at earlier, here, it was a few years later, and there was an ordinance change. The township changed the sign ordinance to limit the signs to a maximum 100 feet versus this 200-foot example. They saw the same variance again, and it was denied. But at least on the facts that we know, for this board, this example is different. You can see some distinguishing factors, right? Years later, an ordinance change in between the two variance requests that supported the denial. The other one I wanted to just hit on quickly, this is just such a super interesting case. The landowner sought a variance to permit construction of an indoor horse training arena 30 feet from a shared property line. They had a 50-foot setback, so it's a 20-foot variance. They had, what is it, 28-acre property. Oh my gosh, you have 28 acres, you could build that anywhere. Well, what if 60% of the property is wetlands? What if they're farming the other portions of the non-wetland property, or they're using it as pasture lands? What if there's, this is Michigan, they're gonna use that area year round, and if they had to build their arena in the middle of the farm field and then walk the horses down to the barn where the stalls are, and now you're exposing them to all those cold temperatures throughout the Michigan winters. So really interesting ways that the unique land use and character of the land, this variance was granted and it was upheld. And again, this might be one of those cases, as Lindsay says, where it could have gone either way in front of the ZBA, because there's evidence on both sides. And if the court does its job well, it's asking, did the local government follow the proper procedures and identify sufficient evidence? And the ZBA did in this case, and so their decision was upheld. And that's it.
This is a quick wrap up.
It's very good. Yes, thank you very much. Really enjoyed your presentation, and is this available as a digital and download?
I can send that to them.
Trade cards.
You can have it, it's okay.
Next second.
So we're moving to,
We're moving on, we're continuing, okay? Report from the planning commission, Mr. Carl.
We had a meeting Tuesday night. We reschedule of a previous meeting where we had way too many people here. So we went over to school, Spy Highway West. Anyway.
Woodland.
I don't wanna go too far with my comments, but say we have about 100 people there. And all the people were very courteous, they gave their opinions, we didn't have any yelling, screaming like I've seen at other meetings. Both for and against short-term rentals. Some for the restrictions, some with restrictions. And some of the ones that all kind of what you've seen. During that public, now in addition to that, there was Rachel Stillman and presented to the planning commission a proposal for an ordinance for short-term rentals. And that was, we were, that should not have been on the agenda. Because we were in no position to rule on that. We hadn't had any discussions on anything, and that came out in the meeting from several people that we a couple of classes ago, we established a ROS subcommittee to get us facts on it. They hadn't even had a meeting yet, and that's not their fault. It just got done. I won't get into the. One of a lot of the people had some very good comments and information. What, as I've been telling everybody all along, we need to read some of the ordinances. Other townships said it's not that we would necessarily have to think anything, but we have to consider. The individual was on the Zoom from Acme Township, and I have to feel that he's one of the officials over there because he gave us an excellent presentation of all the information they went through in coming up with their ordinance. So the ordinance, just so how they got there, and we haven't considered any of that yet. So, so what we did, and we decided, we need to adjust all the information we've gotten, and we need to get our ROS group going and getting us information, and we need to look at these ordinance, and there's been in newspaper accounts of pros and minuses. And one, Ron Pop, he submitted a letter, and he said this in person, his first former township supervisor, and I don't know if this is true or not, but it needs to be investigated. He said that the Michigan courts have ruled that short-term rentals are not compatible with R1 residential neighborhoods, period. They essentially are forbidden, but I don't know. They said several court divisions. We need to investigate. Is that true or not? I don't know.
So you're continuing it on and going next to.
So we're going to be having more meetings with our ROS group. This is going to take several months. It's not going to be done overnight. There's too much at stake. And the suggestion was, well, that, bad, I don't say bad, but that incomplete proposal is better than nothing. No, it's not. Once you put an ordinance in place, we're going to have a hell of a time getting rid of it or changing it. So we need to do this and do it right. And that was a good start. People were there concerned. Overall, I was impressed. I just think it was our fault for bringing her proposal in at this time, because you could go back and say, look, you didn't talk about how many short-term rentals should be in a zone. Who's going to make that decision? How's it going to be made? But there's no enforceable possible capability right now in our township, and all that has to be discussed and resolved. That's important because we can absolutely destroy our community if we make the wrong decision. And I don't know what I'm in a position now in my life that it really doesn't matter to me, so I'm pretty neutral. 20 years ago, I wasn't there. I have no family that's gonna get my place after I'm gone, so I don't know how long I can stay there. I'll stay there as long as I can, because I love it, but, you know, and your health dictates what you do.
Thank you, Darrell. Is it possible to submit, your report as a summary or synopsis in writing?
No. I'm not that good at it anymore, and I'm just not gonna take that back. But that's even better.
Yeah, yeah.
Can you ask, some support from some of the staff?
And that meeting went till 10:30 or
Yeah, it
11
was,
o'clock.
yeah, it was long, so
Oh, you guys are.
it's on Zoom if you want to watch it.
We just went.
So. I'm just gonna give a quick verbal report from the board. Obviously, we haven't met in, 9 months, 7 months, and I can't tell you everything the board's been doing since then, but of note, we just today made a civil infraction ordinance public hearing for September 30th that will be of note to the ZBA as well.
Thank you.
Welcome.
Good.
So you didn't disagree with what I just said about the meeting?
No,
Yeah, very good.
Oh, thank you so much.
I just went out of here now. I went out.
I will. Just to clarify, we have an article in our zoning ordinance, it's Article 21. I'm hoping everybody on the ZBA is aware of this, but in the drawers over there, that we have books that are copies of the entire zoning ordinance, that if you ever are sitting in a meeting and you're curious what that ordinance is, there's 10 copies in the drawers over there that you can use during any meeting. And if you want to come in anytime during the week and check one out, you can allowed to do that. The clerk has numbered them. The reason there was a hearing with the planning commission was because in Article 21, if someone, a member of the public, wants to propose something to the township and say, I'd like to see this paragraph rewritten. Or can we change our setback from 15 feet to 12 feet or 15 feet to 10 feet? They can make a proposal and they can say, if in Article 4 under the schedule of regulations chart, I'm suggesting that we do this, that, or whatever. And it's called an amendment. And so they pay a fee, they apply for it, and they promote it. And they say, this is something I would like to present to the planning commission. And this was on the planning commission's agenda in April. It was on their agenda in May. It was on the board's agenda as well. And Keith came back from his trip and said, and agreed to get this heard. And it's a proposal from someone, a member of the public. It's not something that the board said, we want to do this. It's not something the planning commission said, hey, we want to take on short-term rentals because we think that would be a great thing on top of everything else we're doing. This is something that came from a member of the public. And that's how that process started. It's not something the planning commission had to spend weeks on reviewing anything. It was just something a member of the public brought forth and said, here, I want you guys to do this. And so after 4 months, it finally had a hearing last night at Woodland Schools. So, and it's gonna be deliberated in the near future. So, stay tuned. There's a lot coming. You've got your zoning report in the packet. This is through August or through July 28th. I had 56 permits issued as of the end of July, and I'm probably approaching 70 right now. So it's been a very, very busy summer. I also handed out to all of you, and I've got your information here, Roberto. Yeah, it comes a lot in between the restrooms. And so this is in your mail slot, so just check it every once in a while. But there's an article in here that comes out of Michigan State that talks about different hearings or court cases that have gone to the Supreme Court, and it summarizes them, and I get them once a month from the being a zoning administrator and going through the class. But anyway, it's just very busy. Does anyone have any questions about my report? I think it's in the packet for you. We do have a couple of appeals pending. Obviously, Mr. Mader today, the appeal that they did back in February of 24, had they applied anytime between February of 24 and
February 25 had actually applied to build something to utilize the variance you gave them over a year and a half ago, I would have written them a permit, or Bob could have written them a permit, but they never applied. So just like our ordinances evolve, changes happen, things happen, and so excellent decision to have them just reapply. I encouraged them to do that, but they wanted to take a different path, so I said, hey, you guys are meeting this week, and he knows he's gonna have the paperwork into me by the end of next week in order for us to get it noticed properly. And to get 15 days notice and let all the neighbors know. And just because of whatever was done, this is gonna be a brand new appeal that you will be utilizing a lot of the information you were trained on tonight. So, I have one other appeal that's in the same general vicinity of someone who wants to build a house that exceeds the footprint that's allowed on the building envelope. I will be working with them to see if we can get it to fit the building envelope before it does come to you. Because as a zoning administrator, I like to exhaust all my options before something comes to your desk. Okay, any questions? Great, thanks.
I just want to say one thing.
Yeah.
Thank you. I didn't know I had a mailbox back there, and I've been
You
here
don't,
5
but
years.
Roberto does.
Pardon?
Roberto does.
Oh, okay.
And any ZBA mail or piece of mail is gonna get put here. Yeah,
I thought you meant that we all did.
no, Roberto does, as the chair.
And you arranged this meeting tonight? You invited these people here to speak?
I think this was kind of planned by the supervisor. The supervisor and the clerk planned this meeting tonight. All I did was work a little bit on the agenda to get it posted on the website, but this was all done behind the scenes. That's why I was actually told I didn't need to attend tonight's meeting. And then when I started watching it on Zoom, I thought, nope, I ran home to feed my dog because I've been out since early this morning. I ran home, fed my dog, put him out, and then I ran down here. So,
Let's have an eye to eye anyway. And for the clerk, I want to thank you for that.
Oh, you're
Thank you
Thank
both for being here.
you for having.
I enjoyed this meeting.
Thank you.
Very glad.
Feedback.
My guts ain't wrong.
The other comment for Deb, you weren't here for the public comment?
oh, I did, I heard it.
Oh, you heard it? Okay.
Positive stuff.
Yep.
So nice to hear something positive. No, I did hear it. I sent him a text. And then I shut my phone off and I just zipped down here. I was on for like 15 minutes and I thought, yeah, I better go down there.
Thank you. Any public comment?
That's great, Skip. Oh,
You're not public.
no.
Yes. Oh.
8388 Win Lane. Bummer, dude. I've sat in now almost 9 hours of meetings today. All in this building. And maybe you guys should join me once in a while. You might learn something. Okay, the ordinance that's being submitted by the resident would be great homework for you. Because if you read the ordinance, you would immediately start asking questions. Like I did. And Brian up there is an Annie resident. He comes to our meetings, I go to their meetings. Why? So we know what the heck is going on as private citizens. Yes, Skip, there are some weird people that do that. So the ordinance was presented by a private citizen per the ordinance. Article 21 is important, here's why. Because there's an ordinance and then there's police power ordinance. That's usually your civil infraction ordinance. And those are the rules that protect the people if somebody violates the ordinance. Well, she kind of wrote a kumbaya one, or that's not even close. So I would like someone in this room, please, if you would, explain the difference between what goes to the ZBA and what goes to the PC when you talk about an ordinance. Because I was under the impression that a ZBA could hear zoning ordinances, not general ordinances, because of where the public body and the legislature sit. But maybe you can enlighten that it's changed. You guys got a lot of information tonight. It was a really, really good training session. That's why some of the public comes, because then we learn what's going on and what we need to learn and do. But zoning ordinances should stay here. General ordinances go other places unless I'm missing something. Have a nice evening.
Thank you.
Got one more.
Another one.
Really nominal Karen, I'm pleased to look forward to you folks. I'm also a township trustee, member of the planning commission, and a planner, certified planner for 40 years. I want to ask a few questions of the attorney, if that's all right. Or just general questions about it, that's okay with you.
Ray, you gotta stand closer to the
Yeah, you just raise it up as high as you can, the microphone and there, you know, it's a lot better.
It's just one point, it's not gonna take very long, it's a matter that's relevant to the planning commission and some cases that we had, and I want to talk about use variances for just a moment. We heard a little bit about that today, and I think it was pointed out that a use variance is really a relic from the past zoning state laws that was basically put in place years ago, but in the zoning enabling act of 2006, they removed that, basically that ability, right, so that if you had it before, you could continue, but if you were writing a new zoning ordinance, you couldn't have use variances.
Or townships.
Or townships, right, okay. So I guess that came up here recently with regard to a proposed rezoning that the planning commission was dealing with, and it was suggested that a use variance might be an option for the applicant to consider. And as a planner for a lot of years, I think most planners would generally discourage use variances because they're kind of an alternative to rezoning property. So I wanted, curious, you mentioned that not many of your clients still have use variances in their ordinances. Is that right? They've removed it, if they had it, or they basically don't implement that tool?
Yeah, I haven't seen them in the ordinances, correct, so they don't have the authority.
Well, if they had it, they removed it, and they right through.
Well, I'm not sure, I'm not sure if they've removed it.
Okay, but they don't.
So they don't have.
That may be something the planning commission and town board might want to consider over here in terms of that, because you know, when you consider a use variance, is essentially, in a sense, rezoning property to allow a applicant to do what to do on the property without rezoning it, without the covers. Sometimes actions related to rezoning, so. That's really all I have, I just want to be sure that it's what your take is on that too. We'll pursue that. Thanks.
Well, I answer the first.
Thank you very much. Anyone else?
Can you just answer my question, Mr. Attorney, since I'm a taxpayer? Please.
Oh, yeah, we'll connect after the meeting.
I'd like them to hear it. I already know what it is, but can you just tell them, please?
That's up to the chair.
She wants to know if a general ordinance should come to us.
Yeah, go ahead and answer. Yeah, thank you.
But yeah, they can. So the ZBA is established in the MZA, like we said. But other township ordinances can direct appeals or other matters to the ZBA. Given the expertise that you have in that area as a quasi judicial body, it's a specialty and brings a set of tools to bear that allows the township to again foster that self-government. So yes, the vast majority of what you see is going to be zoning related. Occasionally you may see other land use or regulatory issues from a different ordinance, if that ordinance vests this body with authority to be where the appeal goes.
Does that answer your question?
Not really. Okay. You'll figure it out, read a book.
Okay, do we need a motion to adjourn?
Are there any Zoom comments?
Oh, yes.
Oh, we have a comment on the screen, okay, for Brian, is it Brian? Who's the comment?
Right.
I don't think we are allowed to comment except.
I was like, are you guys following this? Or I don't know.
I was muted when I was on.
Mhm.
You're right, yeah,
That's my mistake.
no comment, some previously in the notes. Sorry.
I was just gonna say, here we go.
It's my mistake.
Sorry. I make a motion to adjourn the meeting.
Support? Scared of support the motion to adjourn. All in favor?
Shut down.
Hi.
Shut down.
Aye. Ayes have it. Thank you.
At 9:38 PM.
Go get some food.